Just a friendly reminder as we get started with the docket, it helps a lot if you keep your microphone muted. That cuts down a lot of the ambient noise and helps keep things moving along nicely.
Yes, I never listened to him. This is
such as the friendly reminder we get with
the two Chelsea guys.
right now. So just do a quick little roll call, make sure everybody's here. Amanda Baker, are you present?
Yes.
Okay, welcome to you. And Mr. Alexander Hall, are you present?
Yeah.
Okay, let me see. Could you speak up one more time, just see if I can catch your Zoom box?
Yes.
Okay, there you are. You're on the Galaxy S9.
Yep.
Okay, perfect. All right, just one moment. All right, so we're here on the state's motion for temporary child support. So I'll first hear from Ms. Looney and then from Ms. Baker and Mr. Hall.
Thank you, Art. So this state has provided proposed orders for temporary child support. We are looking at requesting a transfer payment of $885 for the two children, which would be $442.50 each. We're basing the incomes on an average hourly wage for Mr. Hall for 2020, 2021, and 2023 employment security data that was available to us. That average hourly wage is $27.05. We've calculated that at full-time, 35 hours per week, to give a net monthly income of $3,503. For Ms. Baker, we're also calculating an average hourly wage based on the employment security data for the 3 years of 2021, 2022, and 2023. Her average hourly wage was $23.51, and we have also calculated that at $35 per 35 hours per week. Apologize. I'm giving her a net monthly income of $3,072. So we're asking that the ongoing child support obligation begin in January of this year. We also are asking for back support for the TANF period in the amount of $1,400. That is for the months of June through December of 2023.
Okay, and the obligor parent or the paying parent in this instance is
Mr. Hall, Your Honor.
Mr. Hall. Okay.
I apologize.
Okay. All right. Thank you, Ms. Looney. I'll hear from Ms. Baker next. Ms. Baker.
I'm not really sure what I'm supposed to say. I've never had a court date like this before, so I don't know. Sorry.
Did you receive the documents that the state supplied, like the proposed child support worksheets and the proposed order?
Yeah, I received them, and most of it, like I didn't receive TANF all of those months. I did receive TANF most of those months, but not all of those months. And it does say that I'm like voluntarily unemployed, and I wouldn't say I'm voluntarily unemployed, but that's kind of besides the point. But other than that, I mean, I know Alex isn't working right now, but neither am I. So it kind of just is a sticky situation.
Thank you. Could I ask you a follow-up question? You mentioned that you weren't on TANF for all of those months. And so I'm assuming you're referring to June through December. Which months were you not receiving TANF?
I believe it was October, November, and December.
So June through September, you were receiving TANF, but not November, December.
Yeah, I think I got back on it the end of December.
Okay. All right. Anything else you'd like to share, Ms. Baker?
No, not that I know. Sorry.
No, it's fine. It's fine. If anything comes to mind, feel free to share. All right.
Thank you.
We'll pivot from Ms. Baker and we'll turn the time to Mr. Hall. Mr. Hall, what's your position related to the state's motion?
Like she said, I'm not working right now. I don't think I've ever made $27 an hour in my life, but that's neither here nor there. But yeah, I'm not working right now, and I would like to support my kids as soon as I get a job. But that amount, that's pretty much all my paycheck would be, is like $900. So that'd be pretty much my whole paycheck. So they're gonna have to base that off of my new job that I get. But for right now, I'm not working, so I would like to be able to be put on something to be like the minimum payments or whatever.
Okay. All right. Thank you. And Ms. Looney, any feedback?
Your Honor, we're looking at historical income, so we can't change the amount that we're asking for due to the fact that the children were receiving TANF. and are currently receiving TANF, but Mr. Hall can speak with the support enforcement officer who would be on his case. If he needs to set up a payment plan, they can work that out with him. But we are not able to ask for a reduced amount on behalf of the state.
Okay. And do you have any feedback regarding what Ms. Baker had indicated as far as not on TANF or October, November, and part of December?
I was just looking that up, Your Honor. I'm almost to where I can see what months that was distributed.
Okay. We'll pause and let you take a look at that.
Can I say something really fast if that's okay?
Yeah, go ahead.
I just want to clarify too. So my a year ago, my eldest son died, and so separately, Alex was stepdad, and so we've all been kind of we're not working. It's not because we don't want to work. It's like a mental health, like trying to cope with life and learn how to live life again. So I don't want anybody to think that like I know that he tries, and I know that I try, but like it is hard. It is hard. And it just everything sucks. And 3 other kiddos at home who now have to have like a whole new sense of everything. Because Caden was the oldest and they all looked up to him and that was our normal. And so it's not like Alex is just like not doing anything. It's not like I'm not doing anything. We're just kind of trying to like learn how to live again, I guess.
Ms. Baker, thank you for that feedback. That's huge, and I can't imagine what that's like, and I can imagine it's absolutely life-shattering to have gone through that. So I appreciate that background and context. Ms. Looney?
Yes, Your Honor. I was able to locate the information, and there was TANF for each month between June and December. There was no pause in benefits being paid out. So we would still be requesting for the same amount at the $200 per month for the TANF arrears.
Okay. All right. Thank you. Mr. Hall, were you saying something? I'm not sure if you were in the process of saying something earlier.
Yeah, I was saying we just got our no contact order lifted, so it's not like we've been able to, figure out anything. So it's been like 2 years, 3 years that it was on, and we haven't been able to talk about much of anything.
Okay.
But yeah, that's
so that's now lifted, you say?
Yeah. And like I said, I don't have a problem paying child support, but I'm not going to be able to pay anything right this second because I'm not working. You know what I mean?
Mm-hmm. Yeah. Okay.
So I don't know how I would set that up or I would talk to you about this situation, but that's what's going on right now. I'm unemployed as of right this minute.
Okay. All right. Thanks. Yeah, I think it's important what Ms. Looney had indicated that that you can speak to what's called a child support enforcement officer or support enforcement officer. And there's some flexibility and some flexibility with the payments, and you can talk to them about that. Ms. Looney, did you supply proposed orders?
Your Honor, my notes indicate those were sent over on December 27th.
Okay.
So we may need to resend. I just realized it was quite some time ago.
Yeah, let me just double check because I've got a couple of folders here. Let me just. I thought I saw them earlier, but there are quite a few proposed orders here, so just 1 minute. I don't see them in my folders, and I apologize for that. If you could forward those to the court, that would be appreciated. So basically, I am granting the state's motion for setting child support. It sounds like the Employment Data Service collects information about people who are working, their wages, and how many hours they're working and the like. And so that's the averages that Ms. Looney is basing the child support on. So I'll adopt those levels, set the father's net income at 3,503 and the mother's net at 3,072, and recognizing there's some barriers, or at least right now, related to the death of the oldest son and recuperating from that. And hopefully that you can get back on your feet here soon and be in a better place, and always remember him and the joy that he brought to your life. So that'll set the father's obligation at $885 per month, and it'll start on January 1 of 2024. As far as the back months, there's indication from Ms. Looney that she reviewed the documentation that shows that there's been payments of TANF during June through December. Ms. Baker differs with that. I'm going to indicate that there is that back support due for those months in the amount requested by Ms. Looney. And Ms. Looney will forward those to me and via email, and then I'll sign off on those, and they'll be filed, and then you can take a look at those orders once they've been filed. So
Thank you, Your Honor.
How much are you saying that I owe right now altogether?
I think that Ms. Looney was asking for back support of 1,400 for the months of June through September. Is that correct, Ms. Looney?
Yes, Your Honor.
That was the amount. Any other
Okay, and
questions?
so 1,400 and then $800 a month on top of that,
885 a
Mhm.
month starting January 1.
even though I don't have a job.
Correct. And as Ms. Looney pointed out, you can check with the support enforcement officer about
So
some
am I supposed
flexibility.
to go rob people or something? Or
Pardon
I
me?
don't understand how you expect me to pay $900 a month without a job. But
He just said that you could talk to the support enforcement people.
no, he just signed it in as saying that that's what I owe going forward now every month.
That's correct. And then you can check with that support enforcement for, they have some flexibility based on individual circumstances. So that'll conclude the case for today. Thank you.
And Your Honor, if I can just add one thing. When Mr. Hall contacts, I believe he actually just signed off, but I do want to put on the record that Mr. Hall can also request to be engaged with the Alternative Solutions Program through DCS. When he talks to support enforcement, they help with barriers. They can help him with seeking employment and any other types of services he may need to help overcome barriers that he's experiencing.
Okay, great. Thank you. Appreciate that. All right, that'll conclude the case for today. Franklin, are you on the line today?
Yes.
Okay, welcome to you. And Jeremy Franklin, are you on the line today? All right, Mr. Franklin, if you're speaking, I'm not able to hear you, so make sure you're unmuted, either pressing the icon, the microphone icon, or pressing *6.
Your Honor, I think that Jeremy is in jail.
Okay. All right, so indication is that he's not here. There's no response to my inquiry. We have Miss Looney as present, and we're on today for finalization, I believe. So I have some proposed orders that were supplied by, I believe, Ms. Franklin. So let me just pull those up. I also have the child support worksheets supplied by Ms. Looney. Ms. Franklin, did you receive copies of those proposed, the worksheets and also the proposed order?
Yes.
Okay, do you have any concerns or questions related to those?
No, I do not.
Okay. Any comments, Ms. Looney, about your proposed orders?
We would have nothing to add to what we've supplied, Your Honor.
Okay. And then, Ms. Franklin, you supplied findings and conclusions about a marriage and also a final divorce decree and also a parenting plan.
Correct.
Okay, so I have all those here. Thank you for supplying those. I'll also note that Mr. Franklin filed a joinder on September 6th of 2023, and he was served with those with that paperwork. And so I'm in a position to move forward by signing each of those documents. So I'll do that now. Any questions, Ms. Franklin?
No, that was it.
All right, I'll take just a moment to sign those.
So when would he start visitation?
So you indicated that he's currently incarcerated?
Right. And we do have a protection order that I have to get dropped after this court date.
Okay.
And the kids are on it.
Okay. Yeah, so if there's a court order that prohibits contact, obviously that has to be removed. But then it's indicating in your proposed order that you submitted that the visitation would be a weekend visitation with children as long as he's sober and in contact with
Yes.
children.
Right.
Yeah, so that's so as soon as the no contact orders are removed, then there's no barrier to him visiting with the children.
Okay.
And I'll still in the process of signing. There's multiple documents here, and once I've signed everything, I'll let you know.
Okay, thank you.
All right, so I've signed off on each of those documents. So thank you for preparing and presenting those, Ms. Franklin and Ms. Looney. Any final issues on the case?
No.
Okay.
Nothing from the state, Your Honor.
All right, very good. That'll conclude that matter.
Thank you.
Thank you. You have a great day.
Heather Lucor, if you're here, make sure you're unmuted and state your name, please. All right, not seeing or hearing from Ms. Lucor. Mr. Denlocker, have you heard any communication from Ms. Lucor about her absence or potential absence today?
No, she told me last night, she sent me a long text message stating that, that it was messed up in the paperwork that I served and wished me a good luck in sarcasm for today.
Okay. All right. Thank you. Let me just you had submitted one moment. I have a couple of documents. I'm just going to double check that, make sure I have those documents before me. Okay, so yes, I have documents here. Just pausing 1 second, Ms. Looney, if you have already sent the documents on Baker and Hall, thank you. If you haven't, don't worry. I found them at the bottom of the file.
Thank you. I'll let my assistant know that we don't need to resend them.
Okay. All right. Thank you for your patience. I appreciate that. All right. So,
All right.
Mr. Denlocker, I have proposed orders that have been submitted by yourself and also Ms. Lukor. And I just have those here. So I have from you a proposed order of a parenting plan and a temporary family law order. And it looks like I have 2 parenting plans from you, which is okay. I'm assuming they're the same.
They might be. I sent in a proposed and a parenting plan, temporary order as well.
Okay. Yeah, I'm just looking at them. Looks like they are identical. I mean, the spacing, the handwriting, everything is identical. So yeah. Okay. So as far as the motion initially was, I'll first hear from Ms. Looney, get your input, and then I'll hear from Mr. Denlocker, please.
Your Honor, we would just be asking if the custody is changed to Mr. Denlocker, that we would have a bench order that would end his child support obligation today, and we would cite a new hearing on to address child support in the future.
Okay. All right. Thanks. All right. And Mr. Denlocker, regarding your motion or your request related to the parenting plan, I'll hear from you.
Thank you. So I've been suspecting for quite some time and really couldn't do anything about drug issues with my daughter's mom. I wasn't in a position to have our child under my roof. I didn't have a room for her. I know she needs her own room. I have since completed that, and she does have her own room. She was in a loving home. She's been under her mom's roof during the week for school. Her mom lives like 2 miles away from the school. It's a 2-minute drive or a 15-minute walk. I have put those papers in attached as well.
And that's to the Lexington Elementary?
Correct.
Okay.
When I first submitted the paperwork, I had requested the school attendance records, and it shows that Heather overslept 32 times in 8 months. Emma has 24 days excused from school in 8 months, 12 unexcused absences, and 54 tardies, with a total of 36 days absent. That
little days of absence.
Yes, 36 of them absent in 8 months.
Okay.
That I don't know what's going on there besides what I was stating, that I believe that her mom is using drugs, and hard drugs on top of that leave your system within 3 days. I was requesting a hair follicle test. She has pretty much refused. She did supply a urine test, which I don't think is sufficient. Currently, our daughter she's not wanted to live with her mom for quite some time. She had talked to her mom about it and was pretty much begged to give her a second chance. Heather has tried to pick up Emma twice from school since we've been going to court over this issue. One time I kept her out of school thinking that Heather would do that because I had court that day, and she most certainly did go to the school. Emma was not there. I called her out of school because Emma was scared to be at school and possibly be taken out of school because of her mom. Our last court date on the 3rd, which I had you as a judge, I was just getting over COVID and I asked for a continuance. Heather directly went to her school to withdraw her. Emma stood up, had a private conversation with her teacher, told her that she did not feel safe going with her mom, and that is not me to pick her up early from school. The office relayed the information to Heather Lucor. Later on, the principal, Miss Micheletto, pulled our daughter aside and had another conversation, making sure that she is okay. And Emma told Miss Micheletto the same thing, that she did not feel safe going with her mom, and addressed some of the issues that is going on. I have spoke with Miss Micheletto. She's the vice principal. I asked if she would possibly be willing to provide any information for the court for me. And she said that they don't typically do that, but she would be more than willing to give you any information needed if you guys wanted information from them. I've attached 2 letters that Heather and I received towards the end of the school year last year, stating that they were going to take Heather to court if there was any more further unexcused absences. If she's not using, I don't understand what the problem is. I pick up Emma from the school bus in front of Heather Lucor's house on Friday. And Emma stays with me till Sunday night. I always offer to take Emma home at a reasonable time because it's a school night on Sunday. And Heather chooses to offer to pick her up from me at a set time that we talk about. But every Sunday, she continues to be later and later and later and later. Sometimes she doesn't pick her up till 10:30 at night on a school night. And often they don't even go home right away. She still has to go grocery shopping or something, which I don't understand, given that she's had all weekend to herself.
Can I ask a question?
Sure.
In your temporary family law order, you're asking for a restraining order. And I know that you have some restraints within the proposed parenting plan, but did you have a separate restraining order? I didn't see one proposed from you.
No, I didn't put in a second one because I initially asked for a ex parte restraining order while Heather was still in Tennessee because she had been threatening to take Emma out of the state against my will.
Okay.
I was leaving the restraining order part up to you. Heather's been threatening me. Her family's been threatening me, making phone calls and text messages to my mother, who is terminal, showing up at her house. So our last court date that I had with you on the 3rd, when I asked for a continuance, Heather had gone straight to the school and tried to withdraw Emma, like I had stated. And Emma did not want to go with her. She immediately called the Longview Police Department asking for a wellness check. Officer McDonald called me. I have submitted all the CAD paperwork for that as well. Officer McDonald had called me. I talked to him. He had already spoke with elementary school. And I just told him my side of things. And he said he didn't feel a need to come out and do a wellness check. I told him he was more than welcome, or anybody in the police department is more than welcome to come and check on Emmeline at any time. I'm not aggressive or upset about anything. I just want what's best for our daughter. And I want Heather to get the help that she needs to be a parent. I'm not trying to keep Emma away from her mother. Her mother needs help. And I'm very worried for her. She's surrounding herself with people that don't breathe life into her. And Emma is around constant yelling and screaming. Heather's got a boyfriend that isn't even allowed to see his own child. He is not allowed at their house. Heather rents from her friend.
Mr. Dunlop, would you mind if I just interrupt?
Sure.
I appreciate you sharing that information, and it's information that was mostly shared within your pleading. So I've seen that, and I just see that Ms. Lucor has just joined our call right now. So I'm letting her in. Okay, Heather Lucor, can you hear me?
Yes.
All right, Ms. Lucor, I called your case probably 10 minutes ago, and maybe a little bit less than that. And Mr. Denlocker is on the line. And I asked him if he had any communication with you about your absence here this morning. He indicated that he had some type of communication with you last night. And then I didn't see you here today, so I proceeded to hear from Mr. Denlocker and also Ms. Looney, who's a representative of the state related to child support and the like. Ms. Looney had indicated that she, if there were a change in the parenting plan, then she would be asking for some child support. And then I've been listening to Mr. Denlocker explain his position. So I'm just curious. So at this point, I guess we kind of start fresh with the hearing. So I have proposed orders from both Mr. Denlocker and Ms. Lucor related to parenting plan, restraining orders, and temporary family law orders. So I'm going to hear from Mr. Denlocker if you want to start again, and then we'll hear from Ms. Lucor.
I'm just asking the court to protect Emmeline. She does not want to be in an abusive home. Heather is constantly yelling and screaming with her boyfriend, Adam Davis. He is no longer allowed at their house, even though he still continues to be at their house when Heather's housemate isn't home, which I've provided bench copies of license plates and photos of that. Heather rents from her friend who purchased the house that they lived in. He has asked her not to have him over. He is not allowed at that house because the neighbors have complained so many times from yelling and screaming that Heather's housemate had to ask him to no longer come over. I don't believe that this is a good situation for Emmeline, as well as the other people that Heather chooses to surround herself with. I did some background checks on some people that Heather hangs out with. They have questionable backgrounds, including burglary, assault, drugs, evading police, felonies, just to name a few. I want my daughter to be around who I don't want my daughter to be around, and that she has stated that Adam Davis is not allowed to see his own daughter. I asked the court that this man have no contact with Emmeline. Heather's got a repeated history of hanging out with people that are not healthy for our child. Heather's last boyfriend committed. I don't know that she's ever gone to counseling or anything for this. They were both using drugs together. I've put in statements from Heather's coworkers and friends that Heather admitted to them that she was using drugs. I've asked for a hair follicle test. As of right now, I want what's best for Heather. I want Emma to have her mom in her life. I want her mom to do better for herself. But I'm asking for supervised visits once said things can be achieved. My daughter is she's very special, and she's very scared, and she does not want to see her mom. She told her teacher that she does not want to go with her mom. She has told her mom that she wants to live with me, and that is what I'm asking for right now, is to get Heather back on track. And I care about her mom, and I want Heather to do better for herself and be a better parent. The school attendance, the letters from the school, the constant going over to the school trying to withdraw Emma from school after said court dates. It's just the harassment from her family and blasting me on Facebook all the time with attached. I've attached everything with people stating he needs an ass whooping and blah blah blah, slandering my name. It's just completely unnecessary. I have not sent her one single message this whole time since I put in the ex parte restraining order, and she continues to send me message after message and phone calls. I understand that she wanted to see her daughter during Christmas and her birthday. I get it. I totally do. But Emma is scared. And I just want what's best for Heather.
All right, Mr. Dunn.
He has never brought up any of these points to me that he's concerned or sat down and had a conversation with me. We have been co-parenting together for 7 years now. We've been broken up since Emma was 2 or 3. And we had, I thought, a fairly good co-parenting relationship, which is why we never had a parenting plan put in place. I also had never asked him for child support before this last year, which I didn't ask him for. I applied for TANF. The state went after him for child support. He has been upset about it ever since. He has told me that he wanted me to return payments to him, that he feels he shouldn't have to pay child support. Even though I have Emma 5 days a week, he still feels as though I should. He feels almost as if he has her 50-50, even though he, on a normal basis, has always had her Friday until Sunday. And then I picked her up Sunday and I had her until Friday when she went to school. And that has been our schedule for years now. And I have attached proof from text messages between me and Ryan Denlocker from when I was in Tennessee. And those messages show that I was asking him if he was okay with Emmeline flying out to Tennessee to meet me while my grandma was in hospice, because it was very important to my grandma to see Emma. We had lived with her all the way up until a year and a half ago, and they were very close. Emmeline also expressed to me that it was very important to her to see my grandma, and she was very, overly excited about it once me and her were talking about the possibility, because she was out of school the following week after I had went out to Tennessee. I was only planning to be in Tennessee for the 5 days that I ended up being there. But while I was there was when it was discussed about Emmeline flying out there as an unaccompanied minor. My grandma was willing to pay for the ticket and pay for any expenses that needed. I was discussing the possibility with Ryan. It was never, ever a question that we would return. It was never me leaving Emmeline with him, as in she's moving in with him. It was never a case like that.
Do you mind if I just interrupt? It looks like Mr. Denlocker fell off of the call.
Oh, okay.
So I'm sorry. I
all right, Mr.
pushed the
Denlocker,
button and it kicked me out.
Okay. All right. Mr. Denlocker is back. Go ahead, Ms. Lucor, with your presentation.
Okay. But as far as us being, or me requesting that Emmeline come out to Tennessee, he has from the beginning stated it as if I just left her with him while I moved to Tennessee, and then I'm trying to come back to take her and bring her out there with me. And that was never the case. I was only supposed to be in Tennessee for 5 days, and that was as long as I ended up being there. I went there to see my grandma, who was moved to hospice and not expected to live much longer. Like I said, the discussion of Emmeline flying out there for a week was discussed. He did agree that he would let her do that, but only if I put in writing that I would pay him back child support and that I would allow him to have her every holiday and every birthday, and that I agreed that I would come back on the 25th, which was the discussed date that me and her would fly back. It was never a question of if we were coming back or if we were moving there. Of course, I was never going to just take her to Tennessee or have her fly out there and never return. All of my belongings are here. My home is here. My dog is here. My car was here. I was never, ever stating that I was trying to move there or stay there. It was never a question.
Can I ask you just a directed question, if I may? Mr. Denlocker had raised concerns regarding drug usage. Do you want to address that?
Yes. He has never brought those concerns up to me. I do know that he has asked my roommate about it, which my roommate has told him that he did not believe that I was using any drugs. And I have also it's never been brought up directly to me. But as far as this court case goes, I did provide a urine analysis. I was not court ordered to do that. He did request a hair follicle test. I did not honestly feel as though I needed to provide anything that wasn't court ordered. I did still go ahead and do the urine analysis to show that I am clean and that I am not using drugs. I don't even drink. As far as the therapy goes, I have sought therapy ever. Like his main points, as far as my ex who committed, he claims that I never sought therapy after that point, and I did go to therapy. I have been to therapy multiple times since that point, which was over a year ago, and I am not using drugs. I was not using drugs. I don't know. I feel like this has just been an ongoing accusation of Ryan's. He has no proof of anything he is alleging. He just, in the way that he's stating everything, he is acting as if Emmeline has been living with him for X amount of time. She's never lived with him, ever. Like, she has lived with me Monday or Sunday through Friday for her. Like, I've never been away from my daughter more than 3 days.
Okay, well, I appreciate the input, and I did read everything that was submitted by the parties, and so we have a big docket today, so I'm going to necessarily have to stop the sharing of the verbal feedback, but I did read everything that was in the file. So just a moment. So with regard to the situation as it stands now, there's a lot of conflicting information. One thing that I'm going to ask both parties to do, I want you both to take a hair follicle test no later than Friday of this week at 5 p.m. So you both will need to pay for and submit to a hair follicle test, and we'll be back here on the 21st of February at 9 o'clock in the morning to review those results. So once you get the results back, you'll need to file those under seal with the court and provide copies to the other party. I'm also appointing our family investigator, Ms. Schaefer. She's going to do an investigation where she'll do a quick investigation to check for safety in the particular homes, because, like I said, there's allegations flying both ways of domestic violence and drug usage and the like. And so we'll return on the 21st of February for her report, and she will be in touch with you. In the meantime, I'm prohibiting either party from introducing or continuing to expose the child to any romantic interests. That both parties are prohibited from removing the child from the state, and both parties are prohibited from changing any school enrollment or school status of the child. For now, it's going to be a 50-50 plan. So starting Friday, January 26th, after school, if school is in, if school's not in, then 5 p.m. Then that will start Mr. Denlocker's week on from Friday at after school or 5 p.m., depending on school status, until the next Friday at 5 p.m. or after school. And then at which time it would be Ms. Lucor's time with the child. So that would be, her time would start on the February 2nd. Then it'll continue to alternate in that fashion. We'll be back here on the 21st of February to hear from Ms. Schaefer related to her investigation, and then we'll take additional steps forward to address the concerns that the parties have raised. So any questions from the parties?
Yes. Could you state the dates again? And, Emmeline doesn't want to go with her mom.
So I've made my ruling so that you asked for a request for your date of Friday. Your parenting time starts on Friday the 26th, and then Ms. Lucor's parenting time will start on Friday the 2nd, either after school if school is in session on that day, or 5 p.m. if it is not. And then you'll continue to alternate weeks in that fashion. So I will draft a bench order to that effect. I'll file it, and the parties can look for it in Odyssey. And we'll be back here on the 21st to review those results from the family investigator.
So what happens until Friday? Is she supposed to be with me, or how, or does...
Wherever she's currently residing, that's where she'll stay until that Friday.
So
So
I'm sorry, Friday, January 26th, because she has been with
from
him
whomever's
because
home she left to go to school today, that's where the child will stay until Friday. And if the child's been with dad, then she'll stay with dad until
Mhm.
Friday. If she's been with you, then she'll stay with you until Friday.
Okay. So then he would have her until next Friday, because his would start this Friday until the following Friday, and then next.
Correct. And then on February 2nd, Friday, would start your time after school. School is in session, or at 5 p.m. if school is not in session. Looks like Ms. Lucor is frozen. So I'll draft an order and submit that to the parties. We'll submit it to the court for filing. Mr. Denlocker, any final questions?
I'm on probation, and I do take random drug tests. I have to call a hotline every single day. It screens for everything.
So you're asking about the hair follicle test?
Yeah,
So you're ordered to do that, to take
okay.
it?
Yeah, okay.
All right, so that'll conclude the hearing. We'll see everybody back here on February 21st. Curtis Hart, are you here?
Thank you.
I am here.
Okay, good morning to you, Mr. Hart. And is Catherine Hart here today?
I'm here.
Okay, welcome to you, Ms. Hart. And I see Ms. Call is present. And did I pronounce your last name correctly, Ms. Call?
Typically it's Kale, but I will tell you I don't correct anyone because that German spelling, it just is what it is.
Okay. All right. Thank you, Ms. Kale.
You bet.
So she's the guardian ad litem. She's present. I hadn't noted that we're here today or related to hear from Ms. Kale regarding the presence, I believe, of Mr. Kevin Johnson during visits and any other additional information that Ms. Kale wants to share. So I'll turn the time to Ms. Kale.
Okay, thank you, Your Honor. Good morning. So I have spent quite a lot of time on the case at this point. I've gotten to know Eric. We kind of thought we had come to a conclusion on this case. I had submitted a number of recommendations to the previous commissioner who was working on this case. She did speak out loud in court that she wanted to adopt my recommendations. However, that didn't go into the clerk's notes. And so, Mr. Hart, there was never another final parenting plan filed adopting those recommendations. And so we ended up in this sort of gray space. Mr. Johnson moved in with Ms. Hart, unbeknownst to Mr. Hart or myself. Mr. Johnson was the subject of some very serious domestic violence issues, very serious substance abuse issues. He did complete drug court in Clark County. He has now, I believe, just over 2 years sober. Ms. Hart felt like this was a good enough reason to bring him into Eric's life. She felt he could be safe. Also, Mr. Johnson is the father of Ms. Hart's second child. And so wanting to bring the family together was Ms. Hart's intention, which I can appreciate. However, one of the recommendations I made in my guardian ad litem report is that neither parent introduce Eric to a romantic partner unless they were legally married. I was particularly concerned about Mr. Johnson because I had information that they were still having contact and that Ms. Hart's intention was to reconcile with Mr. Johnson. My intention in that recommendation was to prevent introducing Mr. Johnson to Eric at a very fragile stage in Eric's reunification with his mother. We had many years go by where Eric had no communication with Ms. Hart and was separated from her. My concern is the history of substance abuse and domestic violence. To Ms. Hart's credit, she herself has a year of sobriety and has been doing very, very well. She's been very forthright with me. She's very communicative with me. And we've had several conversations in which she's made it clear to me why she wants Mr. Johnson introduced. After spending some time with Eric, after Eric has had some counseling and is working on reunifying with his mother, I stand by my recommendation that we allow Eric to continue that process and become more stable in the world of his mother at this point before we introduce new partners, particularly partners who have a history of having very dramatic effects on this family negatively. I appreciate very much that Mr. Johnson is Ms. Hart's the father of Ms. Hart's second child. I appreciate very much her desire to bring this family together. But what we know about Eric's diagnoses and his neurodivergence is that moving at a slow rate of pace, allowing him to adjust on his own time is how we see success with Eric. He has started to improve dramatically in school. He's very happy to have this communication with his mother and have these visits with his mother. But my concern is that introducing Mr. Johnson at this stage could deeply impact his ability to keep continuing forward in that growth. Further, there's some concerns around Ms. Hart in terms of her housing and Mr. Johnson living there. I think there are some things here that need to be seen through to the other side before we start bringing him into Eric's world as well. I also know Mr. Hart has some very serious concerns that I think would be fair to hear him on if you're comfortable with that, Your Honor. But that's where I'm at with this case at this point.
Thank you, Ms. Kell. So, Ms. Kell, you mentioned your primary efforts were related to Mr. Johnson and how that impacts on the son, Eric, and your recommendation is to hold off on having him be in the home being exposed to the son unless Ms. Catherine Hart is married to Mr. Johnson. That's kind of the gist.
At this point in time, yes, but the fact that this has happened as quickly as it did gives me more concern. Ms. Hart has mentioned to me that they consider just going and getting married. So I'm concerned that the intention of that recommendation is getting lost. The intention of that recommendation is that Eric not be exposed to romantic partners before he's ready. So I think the language of that recommendation on my part should have been adjusted. My recommendation at this point is that he not be exposed specifically to Kevin Johnson and that he have time to reunify with his mother in a stable way over a long period of time before we make that adjustment.
Thank you, Ms. Gill. All right, we'll hear from Mr. Hart and then from Ms. Hart.
Mrs. Kell said basically like pretty much most of it. This was a big concern to me because the way I went about finding out about it was just in a casual conversation with my son. He was asking about, because he knew that he wasn't supposed to be around Kevin, and he asked at one point, if I'm not supposed to be around Kevin, how do I spend the night there, or something to that effect. And I was like, well, what do you mean? And that's how we found out. It's not like she told us that he was to be there. And then almost immediately upon bringing it up, she said, well, the judge said I can bring this back to court if I need to. She takes the words from the GAL and like twists them up and puts them out of context to where she's saying like she said this, and it's just a whole lot of mess. And I'd rather it just be, I guess, more plain than it already was, because it already said not to be around, and she just went ahead and just decided not to listen to that part. So it's my main concern is everything was going really well because everybody was following the rules that were just plainly laid out, and then all of a sudden they weren't. And then when all this started, the last commissioner asked Catherine if she could, I'm not exactly how she put it exactly, but it was like, can you accommodate Eric to come over and visit and not have Kevin Johnson around? And she said, instead of just saying yes, she said, I'm sure we can work something out. And instead of just having Eric come over for the weekend visits like she's supposed to every other weekend, she only sees him on Saturdays when Kevin's at work. And it's pretty much completely dependent on Kevin's work schedule when she sees him. And at one point, before the holiday started up, I was letting him go over there on every Saturday because she was only seeing him a little bit. And this happened for like about 3 weeks, I think. And then suddenly something happened and a conflict came up in the schedule. And I'm like, well, it's actually my weekend. He's going to come with us. And she's like, well, I get him every Saturday. And I've been getting him every Saturday. It's like, well, you don't get him every Saturday. Like, you have him every other weekend. You're choosing to see him only on Saturdays, though. That's up to you. Like,
and Mr. Hart, that's based on the 2017 parenting plan
and the parenting plan that we had worked. That we were going to turn in right before she moved Kevin Johnson in, because we had agreed to a parenting plan, and I was just a couple of days, like I just had to fix a couple of spelling errors basically and a couple of date errors on it to turn it in. But then we found out that Kevin moved in, and then all this happened, so it never got turned in. But
okay, so we're operating under the 2017 parenting plan. That's what's in place currently.
Currently, still yes.
Okay, all right. And so your request at this point, you're in agreement with Ms. Kell's recommendation that there'd be no contact between Eric and Mr. Johnson until a reunifying counselor indicates that he's in a position where he can have that contact?
Yes. Sure. Yes.
Okay. All right. Thank you, Ms. Hart. I'll hear from you.
Okay. And Your Honor, at this time, because of my conversations that I've had with Ms. Kale, I also feel that it's important that Eric and I have the time to strengthen our relationship before we reintroduce another parenting figure in his life. So I do understand that at this time. I am comfortable with having him on Saturdays. If his dad wants every other Saturday, then that's fine too. I have not had a chance to speak with Eric's counselor yet. I'm still waiting on a phone call back from her. But like I said, I do agree that some time needs to happen before anybody is reintroduced to him, specifically Kevin. I asked the court that after a year that we begin to slowly introduce Kevin into Eric's life and to work on a whole family here. And I think it should be a slow introduction after that year that Eric and I have with our in-person visits. After that year, I think it would be appropriate for visits to be where my mother would be present. She'll be moving back here from Nevada here in a couple months, but where my mother would be present to provide any additional support for Eric. I know Mr. Hart has been asking that no contact be made for a total of 2 years. But I think a year with me and Eric having our time to build our relationship, and then a year with the support from my mother during that introduction period for a total of 2 years.
Okay. All right. Thank you, Ms. Hart. So, children are individualized, when they're ready. I don't know. They might be ready sooner. They might be ready later. It sounds like your son is making progress, and we don't want to interrupt that. And it sounds like there's an agreement by Ms. Hart that she understands that it's important that he's ready when he's ready for that introduction to other potential figures within the home. So I'm going to adopt that recommendation by Ms. Kell, also supported by Mr. Hart, and sounds like supported by Ms. Hart, that there be no interaction between the son, Eric, and Mr. Kevin Johnson until, according to the counselor, he's ready for that. And then the focus will be now, between now and then, continuing to strengthen the relationship between Ms. Hart and her son, Eric. The parenting plan from 2017 indicates that Ms. Hart has parenting time on Saturdays from 2 to 8 every other week. That's the order that's in effect. That's the order that controls, and that continues at this point. I'll do a bench order today that lays out that there's not to be any contact between Mr. Johnson and Eric unless specifically provided by the counselor. And then if that's provided by the counselor, then there need to be noted up so the court could review that before any contact occurs. So it's not to be unilateral by any party introducing or having contact between Mr. Johnson and Eric unless the court specifically says that's okay after receiving input from the counselor. So that's where we're at, and what the timeframes are as far as Eric's improvement of his relationship with his mother. We'll have to just wait and see how that goes, and hopefully it improves and is good. So that's the court's ruling. I'll ask the parties if you have any questions about the ruling. Ms. Kell, any questions?
Not at this time, Your Honor. Thank you.
Okay, Mr. Hart, any question?
Not that I believe so.
Okay, Ms. Hart, any questions?
No, Your Honor. Thank you.
Okay, all right. Thank you all for your input. I appreciate that. I'll have that order. I don't think it'll be filed today. I've got a pretty busy afternoon, so hopefully by the end of business tomorrow it'll be filed, and you can get a copy thereafter.
Okay, thank you.
Okay.
Thank you, Your Honor.
That'll conclude the efforts for today. Thank you.
Thank you.
John Gilbert, are you here today? John Gilbert? Not hearing a response from John Gilbert. I'll ask if Aaron Gilbert is present. Aaron Gilbert?
Yes, I'm here.
Okay, all right. Thank you. Good morning to you, Ms. Gilbert.
Good morning.
I don't, apparently, I'm not hearing from John Gilbert, so let me just specify, Mr. Gilbert, if you are on the Zoom call today, if you please press the icon, the microphone icon to unmute, and then also if you're calling in using a phone number, dial *6. That will alternatively mute and unmute you. Again, John Gilbert, are you here today? All right, there's no response. My understanding of why we're present here today is related to the status, getting an update on the psychological evaluation and parental risk assessment. And from my review of the file, I did not see that. So we'll hear from Mr. Lawrence for an update.
Your Honor, I've had no contact with Mr. Gilbert recently. He is very much aware that I had requested this and that the court had ordered it. And I gave him information as to who to contact, and I've heard nothing since. As the court may recall, this matter was on for last week, but due to the ice and snow, it was kicked over. I tried to reach him to let him know that the court was going to start an hour later, and he didn't show up for the hearing, and so I'm not sure if he was aware that today's hearing was to take place.
Okay. And so, and he is the subject of the psychological evaluation with the parental risk assessment, is that correct?
Yes.
And if that having that not be or having it be incomplete, do you have any recommendations? Because last time I understand that the visitation was status quo. There was no change in the visitation for father.
That's correct, Your Honor, and I would again ask the court to continue with the status quo.
Okay. All right. Thank you. Okay, Ms. Gilbert, happy to hear from you.
Yeah, I honestly haven't heard from John, so I'm not sure if he has done any of this or knew about court or anything. So, but yeah, I do just have a question on the supervised visitations. So now we're just doing Saturdays, but he's requesting 2 days a week, which I do understand that he wants more time. I mean, I guess he's not here to even do that, but I don't want to have to drive down there 2 days a week. It's a lot of gas. So I was just going to bring that up, but John's not here to discuss it, I guess, anyway. So.
Yeah, and so I'm looking for a particular order that specifies the parenting time. Can any of the parties point me to a kind of a date and time when that order may have been entered? There's been a variety of them entered. Well, here's one from May 8th of 2023. It says, Mr. Gilbert may have supervised visits with the son once per week for 4 to 6 hours of reconnecting families. He's responsible for the costs, and he's to cooperate in bringing, Ms. Gilbert is responsible to cooperate in bringing the son to the visits. So that's the order that exists. So there's been no change to that, unless the parties can point me to something different.
Nope, I think that is where it is. So.
Okay. Let me ask the parties, if the psychological evaluation is important, it sounds like the visitation occurs at a professionally supervised facility. Does there need to be added pressure to Mr. Gilbert to comply and get the evaluation done, or does there still just let it ride and then the child is at least safe during supervised visitation? Mr. Lawrence?
Well, Your Honor, Mr. Gilbert has been very resistive throughout this whole process. We had asked for a drug and alcohol evaluation. He fought that for a long time and finally complied. But the issues in the home is the stability and the potential use of drugs still in the home. And so that's why I was requesting the psychological evaluation with the parental risk component. And I would think that he should have at least started the process and tried to communicate with us as to what his intentions are. And I'm not hearing anything. And so my concern is that he just wants to continue on as we're doing ad nauseum. I would recommend that the court invoke some type of pressure to get him to comply with the order.
Thank you. Ms. Gilbert, if the court were to suspend visitation of Mr. Gilbert and the child until he completes the evaluation, does that do more harm or good to the child?
Probably more harm. Yeah, unfortunately. He does like the, weekly visits, so.
Okay. Yeah, there needs to be some movement on that, on the psychological evaluation with the parental risk assessment. And at the same time, I need to be sensitive to the well-being of the child. And if the child is having visits that are positive and safe because they're professionally supervised, it's hard for me to apply pressure such that I would remove any visitation. And I don't really know much more any other tool that's going to get Mr. Gilbert to do what we've asked him. I mean, he may be eternally in the supervised visitation mode on every other Saturday or once a week on Saturdays. So at this point, I'm going to hold off and we'll just. I'm not sure if an additional hearing is warranted at this point. It'd be status quo if he wants to continue, if he is using drugs, or if there's still concerns about his psychological well-being. That can be mitigated and somewhat controlled in the professional supervised setting. And if he wants to make changes to that, he could bring a motion to the court, or if Ms. Gilbert feels that there needs to be a change, then she could bring a motion to the court. If Mr. Lawrence feels there needs to be a change, then he could notify the court of a need for some type of adjustment. So I guess that's a long way to say that I'm not going to do anything today. I think we're going to move forward with the status quo. If there's new issues that arise that are of concern to the parties, the best interest of the child is impacted in some way. Certainly the parties are free to bring that before the court. Otherwise, we'll continue with the visitations that are supervised where he's protected. And that seems at this point, according to Ms. Gilbert, still in the child's best interest. Any questions with that, Ms. Gilbert?
No, thank you.
Okay, Mr. Lawrence?
No questions, Your Honor.
Okay, thank you both for your input and assistance. Bobby Giske is
Thank you.
present.
Thank you.
Yes, I am.
Okay, welcome to you, Mr. Giske. And Tiffany Giske, are you on the line?
Yes, I'm here.
Okay, well, welcome to you also. Okay, we are here today on Mr. Giske's motion for adequate cause to modify a parenting plan. From my reading of the file, there's an existing parenting plan from February of 2020. I've read the input from both parties, and I'll just note for future reference and a reminder to all that under Local Rule 88C, reply declarations are permitted, but they're limited to a total of 4, not 8. So I think Mr. Giske filed in excess of that, so I stopped reading after 4 and did not read the remainder, and I'm not considering those. So this is your motion, Mr. Giske. I'll hear from you on your motion for adequate cause and the motion to modify parenting plan.
Right. The main reason that we're here, back on December 15th of 2023, I received a phone call from a friend alarming me that the altercation that involved mine and Tiffany's oldest son with their daughter, who roughly was 3 or 4, which is 10 years under, had occurred at their house. And there have been other issues at school, minor issues at her house that just leaves you wondering, well, what's causing all this? And then I got the phone call altercation with this 4-year-old, and I reached out to CPS and everything, and they told me I need to get him in control. And so I'm trying to get him into a controlled environment without any more him spiraling out of control.
Mr. Giske, you mentioned something about activity with the 4-year-old. Did you write that in any of your pleadings?
No, I did not. Sharon Brown was going to comment or something, the CPS worker I'm involved with.
Okay, because yeah, that kind of, that stands out, but I don't recall reading anything about that in any of the declarations. Okay, thank you for clarifying that. Go ahead, please.
And so I've been in contact with Sharon Brown from the Cowles County CPS. I sat down, talked to her, explained everything. She reached out to me and told me I needed to reach out to Clark County CPS because of Tiffany and the altercation happening in Clark County, and me living in Cowles County. They can't have jurisdiction over there. And so I talked to Clark County through Sharon, and he's in psychologist, a counselor. He's going to, I forget what it's called, but he's going to a victim counseling because no one was fully hurt, but they want to hopefully get him the help wherever his mental state is going. And more so, there have been altercations where our younger son, Bradley, witnessed her fiance tell her he was going to F her, and we don't know where he got the motion from, but he grabbed our older son by the throat, threw him on the bed, put his knee on his chest, and told him he was going to F his older brother at her house. And then we all sat down and talked.
Can I interrupt again?
Yes, sir.
That information, kind of the details of what did or didn't happen, did you include that in any of your pleadings?
No, Your Honor. I just checked neglect on her house.
Okay, so that's some of the issue that when I was reviewing the file, you indicated that these were the concerns. Self-harm, left in an unsafe, unhealthy environment, supervision lacking, involving in adult decisions, mental instability, behavioral issues, not attending medical or dental vision appointments, and yes, not involving kids in adult activities. But you didn't give me any specifics, so you gave me conclusions, but not any specifics. And now today you're giving me specifics, which makes it challenging for not only myself, but for a party that's responding to a motion for adequate cause, because they don't know what's coming. All there are some generalities, and all of a sudden here are some specifics thrown at the court and at the responding party. So it puts me in a difficult position, because in reading your pleadings, there's basically conclusory allegations, but with no support to them. So I'm not sure if, at this point, I think we probably need to, if this is, the allegations are as you lay them out to be, I think they need to be put in writing so the other party can have an opportunity to review those, and the court can have an opportunity to review those and come back and address those issues more fully. Because right now, neither the court nor the responding party has ever heard of any of this. I mean, maybe Ms. Giske has, but the court certainly has not. I just throw that out there, not to be obstructionist or to delay, but the fact of the matter is it's kind of an issue of due process and having an opportunity to have notice of what the claims are and have an opportunity to respond and to have a court that's prepared of having reviewed that information. Do you have any thoughts about that, Mr. Giske?
Say that again.
Do you have any thoughts about that as far as continuing this matter to include?
I understand that I need to put it in writing for you. I do understand, and I apologize.
Okay. Ms. Giske, do you have any input?
No, I guess not.
Okay. So let's see. There's a fine line that I need to balance. One, folks who are not normally involved in the legal process are representing themselves. And so there's not the same level of familiarity or expertise, if you will, as far as how to prosecute or bring a case. And I also have to balance it against efficiency of the court and not unduly burdening the parties with excessive litigation and court dates. Here, I think the allegations that I've heard today, at least verbally from Mr. Giske, warrant continuing the matter to allow all parties to have their say about what they feel is or is not happening. So that's a long ways about for me to say that I'm going to continue the matter. Mr. Giske, you'll have to submit those any declarations. And again, please review Cowlitz County Local Rule 88. That's found on the court's website under rules. And then you'll need to submit that and serve a copy on Ms. Giske. Ms. Giske will have an opportunity to respond and file her response. I think we'll come back on the 14th of February, which is a Wednesday at 9 a.m. How does that court date look for you, Ms. Giske?
That's fine.
Okay. Mr. Giske, how does that date look for you?
That's fine.
Okay. We'll reconvene on the 14th at 9 a.m. Mr. Giske, make sure you get those declarations filed no later than and served upon Ms. Giske by the 2nd of February.
Yes, Your Honor.
Okay. All right. That'll conclude the matter for today. We'll see everybody on the 14th of February, 9 a.m. Welcome to
Okay, thank you.
All right, and
Thank you,
is
Honor.
Billy Geidel on the line? Billy Geidel? I know Mr. Geidel's been on. He's been having audio troubles all morning. He's been messaging on the chat feature to everyone, indicating that he's doesn't have any audio.
Oh, okay. Can you hear me now?
I can. Good morning to you, Mr. Geidel.
Thank you.
How do you pronounce your last name?
Geidel.
Geidel.
And the first name's Adil.
Very good. All right. This is Ms. Andrews' motion related for a motion for contempt related to maintenance. And this stems from a August 2013 judgment of back support in the amount of $7,200. Subsequently, there was a adjustment to that payment. There was a payment plan ordered $450 a month, and there was a time where there was an adjustment in March of 2018 where for a period of, I think, 2 months, it was reduced. Mr. Geidel was ordered to pay $200 a month, at least for 2 months, and then it resumed. Ms. Geidel brings the motion, or pardon me, Ms. Andrews brings the motion, so I'll hear first from Ms. Andrews. Ms. Andrews?
Yes, thank you, Your Honor. This goes back a very long way. We've been to court, it's now the 4th time. And Mr. Geisel, just because I think in Australia, he thinks that he can get away from it. Each time there's been a judgment and ruled what he needs to pay and when he has to, and I have only ever received one payment, which was years ago. When you ruled the last time, unfortunately, I got kicked off and couldn't get back into the room. So I contacted the court and found out what you had ruled. He did not pay half for 2 months, and he has not paid. This outstanding is now causing me major grief. I do not have all of my paperwork, Your Honour, because I had a very bad accident where I broke my back in 2 places. Mr. Geitel was well aware that I was looking to be homeless. Because of that, I have now been placed in a home for people with disabilities, and I have a lot of expenses that go with the accident, and I'm wanting Your Honour to somehow make Mr. Geitel uphold his responsibility to pay this plus the 12% interest. It's now in total, I think, 13 years since it was first ruled or the first judgment. And this is the 4th time we've gone back to court, and he just, no matter what you tell him he needs to abide by, he doesn't do it.
All right. Thank you, Ms. Andrews. Mr. Geitel? Okay, go ahead, please.
Your Honor, I'm sorry. Can you hear me now?
Yes.
Thank you, Your Honor. Was there a question, Your Honor?
I'm turning to you for your input regarding the motion for contempt.
My input would be on my declaration, Your Honor.
Okay, I've reviewed that.
And-
What do you want me to consider?
Okay. That exactly. I'm just looking for the rule law on it, Your Honor.
Okay. All right. Thank you. So in reviewing the file, this is what I learned, that the divorce was finalized in August 26th of 2013, that there was an unpaid temporary maintenance award that was converted to a judgment in the amount of $7,200. And as of August 19th, in the decree of dissolution, which was filed later on the 26th with an amended, it says the respondent shall be granted a judgment against petitioner, Mr. Geitel, for unpaid family maintenance under the temporary order in the amount of $7,200, which shall bear interest at 12%, commencing the 20th of September 2013. It's again reiterated in the findings of fact and conclusions of law that there's a temporary order of $7,200 and the judgment is awarded. In the amended decree, there's also that same $7,200 judgment that's awarded. Later on, in October of 2017, there was an order regarding payment of a judgment owed, and that indicates that at commencing November 5th of 2017, Mr. Geitel shall pay $450 a month on the outstanding judgment owed to Ms. Andrews pursuant to the decree in August of 2013 until it's paid. And in March of 2018, there was a motion brought by Mr. Geitel to suspend his payments for a period of time because he was involved in a motor vehicle accident, and asked us to suspend the $450 a month payments. And then in April of 2018, there was an order that reduced the payments to $200 for 2 months, but then it goes back to $450 per month. Mr. Geitel argues in his response that the judgment of $7,200 has expired and it was not renewed by the 10-year period required by statute, which would have been August of 2023. And therefore, he says that he's not obligated to make any payment on that. What is important to understand here is that there is a court order to make monthly payments, and that's the motion that Ms. Andrews has brought. The motion is that there is an order that required Mr. Geitel to make monthly payments. He's failed to do so. There's no showing that he's unable to do so. There is nothing in his declaration that says, hey, I'm indigent, I'm on the streets, I don't have that amount of money. There is nothing of that sort. His response was the judgment is void because it's expired. So Ms. Andrews did not file for an extension or a renewal of that judgment for an additional 10 years by the time frame required by statute, which would have been prior to the August 2023. But what's important to note here is that on multiple occasions, the court did order Mr. Geitel to make payments. In 2013, the court ordered him to make payments. He did not do so. In 2017, ordered him to make payments in a reduced amount. He did not do so. There was the March 2018 order. He was ordered to pay certain amounts at his request. He failed to do that also. So that is contemptuous. So I'm finding Mr. Geidel in contempt for failing to abide by the court's order to make monthly payments. Mr. Geidel's argument that because the judgment was void, because is void now or non-existent, and I can't find a contempt, flies in the face of the court's authority to order people to take actions. While the $7,200 may not be collectible at this point in time, there is contempt, and I'll make a finding of contempt. I'll impose a $1,000 civil fine. And that fine will go directly to Ms. Andrews. That'll need to be payable within 30 days. So no later than February 21st is the due date. If it's not received by that date, Ms. Andrews, you'll need to file a motion to why Mr. Geidel should not be held in further contempt with up to and including the possibility of jail. So that'll be the court's order. Any questions, Ms. Andrews?
Yes, Your Honour, that's a fine for that, but we still don't have anything in place as to me getting the money that's required. Definitely the fine.
I understand that. The fact of the matter is the judgment was not renewed in a timely fashion. Therefore, I'm not certain that it's in existence anymore.
But each time we went back to court, you made a judgment on it.
That's one way to interpret it. However, a judgment generally is renewed by documentation, so it's clear of what's happening. So when a judgment is renewed, there were separate orders in which there was adjustments to the repayment dollar amount per month. However, there was no specific reference that the judgment was being renewed, and that's the difficulty I have. I'm actually quite sympathetic to your cause. It sounds like Mr. Geidel has thumbed his nose at you and thumbed his nose at the court, and has refused to make any payment. However, there's particular rules that need to be followed regarding judgments. And the more I think about it, I think that the $1,000 civil fine is inadequate. I'm going to make that $2,500 payable within 30 days by the 21st of February. Mr. Geidel, I'll hear from you. Any questions about the court's order?
No, Your Honor. Except when I pay this, how should I pay it? Just on a money order and keep the receipt, or what?
Yeah, it should be submitted to the clerk's office. It'll be held in an account in the clerk's office, and then it can be distributed to Ms. Andrews thereafter. If you make that $2,500 fine, if you pay that, then that'll purge the contempt.
Thank you very much.
We will be back here on the 28th of February at 9 o'clock to make sure that payment has been received. If it's not, then we'll take additional action to make sure it is.
Your Honor, if the payment has been made, do we need to come back?
Yes.
Okay.
There's just a concern of what I call a willful disobedience of the court order. So having you come back an additional day is not going to hurt.
Thank you, Your Honor.
All right, Ms. Andrews, any final questions?
No, Your Honor, do I just come back via the same means I came in today? I don't have to file any other paperwork. I just return on that date. Yeah. Okay, thank you.
Correct. Yeah, just go to the court website, look for the link on that particular day, and then you can participate via Zoom.
Yeah, it's very, very sad, Your Honor, because I just don't understand this. I just don't get it, because I thought by going back to court each time and having a judgment that you've ruled, and I just have to accept it.
Yeah, I understand. I'm sympathetic to your cause and your position, but I just think legally it's not accurate. Unfortunately.
Okay.
Okay. All right. Thank you.
I've got no means to fight that. That's it.
No, certainly. Once I've entered my order, if you feel that's an error, and everybody's entitled to appeal a court's ruling, and that's welcomed. If you feel that my decision today is an error, you could certainly file a notice of appeal and ask a reviewing court, the Court of Appeals, to review it, because I may be wrong. I'll be the first to admit that.
what was the notice again? Notice of appeal.
Could you repeat that?
Did you say that if I want to fight it, I put it under a notice of appeal?
Correct. Once I've submitted the order that imposes the civil fine and the purge conditions, then you have 10 days within that being filed to file a notice of appeal with the Court of Appeals.
Wonderful. And could you give me approximate time of when you would be filing that, please?
I'm anticipating by close of business tomorrow.
Tomorrow. Okay. Thank you, Your Honor.
Okay. All right. All right. That'll conclude the hearing for today. Thank you. And I'll ask if Anna Manley is present.
I am here.
Okay. Miss Manley is present. Just a moment. Okay. This is one moment. We're here for Ms. Manley's motion for contempt. It looks like service was effectuated upon Mr. Fike on January 10th, so service appears to be proper. And so I'll hear from Ms. Manley related to your motion, then I'll hear from Mr. Fike in response.
Yeah, on New Year's Eve, it was my scheduled parenting time from 5 p.m. on 12/31 until 5 p.m. on the 1st. Mr. Fike did not bring our daughter back to me. I asked him if he could please bring her back. He said it's his time. I sent him a picture of the parenting plan and explained to him how it works, and he still refused, and he just kept her until the next day. This is the second time he's withheld her from me in less than 5 months. And I just feel like he's not respecting our parenting plan or the routines we have for our daughter, who's only 4, at all.
Right,
So,
thank you. And then one point of clarification, if I may, Ms. Manley, there was some indication that your motion may have included being tardy at exchanges. Are you pursuing that as a contemptuous motion?
no, that was more of a mention that the parenting plan is not being respected, just overall.
Okay. All right. Thank you. All right. I'll hear from Mr. Fike, please.
Yes, Your Honor. So in my declaration, I stated that we agreed with during our parenting plan in 2021 that my holiday schedule was lined up with my other children's schedule. Anna agreed to that. I attached with the courts and my filings a copy of the page of my holiday schedule with my 2 boys, which clearly states that I have even years for New Year's Day. Our parenting plan, as you can see, as Miss Manley has filed, says New Year's Eve / New Year's Day. However, as we all know, the holiday is New Year's Day, not New Year's Eve. And Anna had Liliana last year, as so did my boys' mom had my boys. This year was my year, and I tried to let Anna know that. She sees the parenting plan. We agreed on it 3 years ago. I have no intention on withholding our daughter. This is not the second time I've withheld her. I have no interest in angering Miss Manley with fear of what she might do to herself or our daughter. I'm asking the courts to reconsider this and throw this allegation of contempt out. As you can see, that my holiday schedule is the same as it is with my other boys.
Thank you. Ms. Manley, any response?
My only response is that for the most part, our parenting plan does match the parenting plan Mr. Fike has with his ex-wife, but on New Year's Eve, it does not match. 2023 was clearly my New Year's Eve.
Okay. All right. Thank you. All right. So I'm looking at the July 2nd, 2021 parenting plan. Therein on page 4, well, page 3 is the start of the holiday schedule. So the holiday schedule indicates on page 4 that it talks about Thanksgiving break, it talks about Christmas Eve, and it talks about alternating years and even years and the like. So under New Year's Eve, it says New Year's Eve / day begins on December 31st at 5 p.m. to January 1st at 5 p.m. Odd years with Anna Manley, even years with Mr. Fike. So that period starts on December 31st. So anytime you're measuring anything, there's a start time, whether it's a stop clock or a calendar or a running race. There's a start line. The start line here is December 31st at 5 p.m. And that's in the year that it occurs. So in 2023, that was an odd year, odd numbered year. So December 31st, odd number year goes to Ms. Manley. I can appreciate Mr. Fike's argument related to the fact that the holiday is July 1st, or pardon me, January 1st. However, that doesn't hold sway, at least in my mind. I think the plain reading of that parenting plan is that the parenting time begins on December 31st and extends into the new year to January 1st at 5 p.m. So the odd years were awarded to Ms. Manley. I recognize there's disagreement in the reading of that, but my reading of it, the clear reading of it, is that that was Ms. Manley's time and she was denied that. I'll make a finding of contempt and then I'll impose a $100 civil sanction. Mr. Fike, you can purge that by abiding by the parenting plan laid out in next year's New Year's Eve, which is actually going to be your time because that's the even year. So I doubt that's going to be an issue. So that'll be the court's order related to today's motion. Any questions from the parties?
Yes, I have a question, Your Honor.
Go ahead.
Instead of $100, would it be possible for me to get Halloween this year as a makeup day?
I'm not going to be involved in negotiations. I'm imposing that the civil sanction. If the parties want to negotiate something, they certainly can, but I'm not going to be involved in that.
Okay. Is there a time limit to when Mr. Fike has to pay that?
It's within 30 days.
Okay, awesome. Thank you.
Mr. Fike, do you have any questions?
Yes, Your Honor. This is not very clear. The holiday is New Year's Day.
So this is not an opportunity to re-argue the case. Do you have any questions about the court's ruling?
No.
Okay, that'll conclude the hearing. Thank you.
Thank you, Your Honor.
Mr. Lawrence is the guardian ad litem. He is present. I'll ask if Alyssa Gutierrez is present. Alyssa Gutierrez, are you on the line? Ms. Gutierrez, if you're on the line, I can't hear you. Make sure you're unmuted. Pressing the icon for the microphone or dialing via phone number, you can press *6 to mute and alternatively unmute. So Alyssa Gutierrez, are you here? Okay, not hearing a response. And Francisco Gutierrez, are you on the line?
Yes, I'm here.
Okay, welcome to you, sir. All right, so we're here to review Mr. Gutierrez's SUD, or Substance Use Disorder Treatment Program. There was an evaluation apparently completed in November of 2023, and that was filed on December 29th of 23. It recommends outpatient treatment. It makes some observations related to that. So I reviewed that, and those were kind of those screenshots that I think Mr. Lawrence may have filed. I'm not sure, but I did look at those. So I'll hear from Mr. Lawrence first, and then hear from Mr. Gutierrez.
Your Honor, we were here today to review Mr. Gutierrez goes by his middle name, Julian. We're here to review Julian's progress in his treatment. I spoke with him by telephone on Monday, and he asked when would be the latest time he could get the results of that to me. I indicated that I was going to be gone all day yesterday, and and I asked that either he or his counselor email me something about his compliance. He told me that he had a 10 o'clock appointment with his counselor yesterday morning. And so when I got back from being out of town yesterday, I checked my email and I checked it again this morning, and there's no, I don't have an email from either Mr. Gutierrez or from Kaiser, his treatment provider. So I don't have any information to offer the court about his compliance.
Thank you, Mr. Lawrence. Mr. Gutierrez, what can you tell me about your compliance?
I had a really busy day yesterday. I've been meeting with counselor every 2 weeks, and yesterday, like I said, I had a busy day between work and getting stuff done. I haven't checked my KP at the website to receive a letter or a statement that I can forward to Mr. Lawrence.
I need to check
When did you
that
start?
so that I can.
When did you start treatment?
January, no. It was the week before New Year's Day. It was the week before New Year's. I believe it was the December 26th, I believe. December 20 or 28th. I can't remember. I have to go back and look.
How many sessions have you had?
3 so far.
Okay. And have you asked Kaiser for a letter updating the court with your treatment compliance and progress?
Yes, I did. I did that yesterday, and I did not see a letter in the afternoon after I got off work, and I've been doing other activities on working on myself as well. So I just, like I said, I had a busy day, and when I talked to Lawrence about him filing or trying to how do I say it, put in whatever statement he needed, he said if it's not turned in by Thursday, it's too late. So I figured maybe, I don't know, next week or whatever other next court day, I could show proof of this evaluation or counseling that I've been doing.
Okay, thank you. So, Mr. Gutierrez, I'm a little bit concerned by the fact that on December 20th, you were here and we set January 17th as a review date to check your compliance. You've had an extra week from then until now to provide us with a letter of compliance. You've indicated that you asked yesterday for Kaiser to send the court an updated letter regarding your compliance. Obviously, things don't turn around that quickly in any large organization. So I'm concerned that you haven't supplied that. So you've made that request now. So that's good. That they'll supply an order. So I'm going to set this matter over 2 weeks to February 7th at 9 o'clock, and we'll need to have that letter filed, and so everybody can review it prior to that date. So get that letter. We'll review it on February 7th at 9 a.m. Any questions?
Can it just be next? Can it just be next week, and I can provide this letter either today or tomorrow?
February 7th is the date. We'll review it at 9 a.m. Any other questions?
No.
Mr. Lawrence?
No, Your Honor.
All right, that'll conclude today's hearing. We'll see everybody then. Is on the line.
Thank you.
I'm here.
Okay, welcome to you, Ms. Vaughn. And I'll ask if Zachary Kayoshi is present. Okay, welcome to you, Mr. Kayoshi. All right, and
Beth Fellows, GAL, is present as well.
perfect. Thank you, Ms. Fellows. I appreciate that. So it's set today. My understanding, and I'll hear from the parties, is that we're here for a review. So my notes indicate that there was a motion for a parenting plan that was filed back in August of 22. At this point, there's been no temporary parenting plan put in place. Also, I'll hear from Ms. Fellows if you can share with me what was to be reviewed today and kind of what we do next, because this case is kind of stagnated and we need to get some type of temporary resolution. So I'll hear from you, please.
Absolutely. So this has been in front of Commissioner Nelson and Commissioner Carmi. You're right, it's been kind of slow going, but we are here to review Dad's visitation and his compliance with his treatment. He is in treatment with DB or for DB. And so I can report that I have been getting the compliance reports on a monthly basis. I have had contact with his treatment provider. As of the 9th of this month, I wanted to find out how much longer he had to go. At that point on the 9th, he is at level 1, which is where he was. He had a minimum of 24 weeks to do. At that point, he was at 16 weeks. So he basically has 8 more weeks to go as of the 9th. So that should actually be probably about 6 weeks now. The compliance reports are very positive. He has been attending. He is doing the work. There are no concerns. His visitation has been slowly increasing since he has been in treatment. He has also, just to let the court know, he did complete substance use treatment. He's also completed a parenting class. So this is like the last piece that he needs to finish. His visits started off as video visits. Then they went to professionally supervised for 2 hours every other week. Then they increased to 2 hours every week. And then it went to unsupervised in October of last year. And he was allowed 2 hours of unsupervised time, and he had to provide an itinerary via our family wizard. And then in November, I'm looking at my notes here, November, it increased to 6 hours unsupervised time, but he had to remain in the Clark and Cowlitz and Lewis counties. And so that's where we are regarding his visitation right now. He does live up in Olympia, and mom and the child live down here. So he travels down here for the visitation. He has been providing the itinerary. I have been able to catch up with him at one of his visits here recently, had no concerns. I also did a home visit up in Olympia to check out his home, and I sat down with Zachary for a while and talked with him. I've also talked with mom about where we should be moving forward. After careful consideration, my thought was to move forward kind of at a slightly faster clip than mom wanted to. One of my considerations is that dad does live in Olympia. It is a good hour's drive, sometimes hour, 10 minutes, something like that. So that is kind of a distance for a little one. So I was considering looking at an overnight. And the other thing, I should back up just a smidgen, is that dad's days off are Tuesdays and Wednesdays. Mom's days off, I believe, are Mondays and Tuesdays. So it has made the visitation a little bit complicated. But I was like looking at the visitation that we have, trying to figure out how to move forward, recognizing dad has engaged in what he has been ordered to do. And so trying to be able to move forward. Mom is apprehensive and does not want to move forward at quite such a fast clip, going to overnights, going from the 6 hours. So her suggestion was to do 4 weeks of 8-hour visits, day visits, but where dad could take him up to his home. Dad really feels like he has done the work to be able to get the overnights. I do tend to agree that it would be beneficial for the child to at least have some familiarity with dad's home before doing an overnight. So I could potentially see doing a couple maybe of those 8-hour visits and then move to overnights. I did not have any concerns with dad's home. He lives with his parents, and I believe his sister and family lives there as well. There have been concerns about substance use, alcohol, marijuana, and another kind of substance called kava, which I have talked to dad about and told him that my recommendation would be that nobody would be under the influence during his time if he were to have his child there, Corey, and that he needed to talk to his family. He has since communicated with me that he has talked to his family. Everybody has agreed, but I would want it written into the court order that there not be anybody under the influence of any type of intoxicant, and in specific alcohol, marijuana, and kava. So that's basically where I'm at, kind of in a nutshell. I'm trying to bring Your Honor up to speed. There was talk about a halfway point also for the parents to meet. Mom did make a suggestion, which actually I looked at the map and it looked right on target. It would be exit 72. I think it's Napa Vine, but it's Rush Road, I believe is what it is. But that's about a halfway point, and there is a gas station or a truck stop there, I believe, Love's Truck Stop. So that's what I'm looking at.
Okay, great. Thank you, Ms. Fellows. I appreciate that. Ms. Vaughn?
Yep, pretty much everything she said in a nutshell. I was saying to go because he's only had these 6-hour day visits where he's got to be like Disneyland dad, that having this day period, 8 hours for maybe say 4 weeks of day visits in his home for that transition time. My child's only 3 years old. Big transitions aren't exactly easy for 3-year-olds. So I thought it would smooth it a little bit over. And while he's still finishing his DV classes, it would give him time to learn all these new ropes.
All right, thank you. Mr. Kayoshi?
Morning, Your Honor. Yes, when Ms. Fellows came, we did talk about speeding the visits along. I would like the overnights. I feel like I've done enough. I've done a lot.
No, they didn't
and
say fast enough.
I'm still on track with treatment. I'm in compliance. I've done the hair follicle tests. I've done the substance abuse, completed that, the parenting class, and completed that as well. I feel, I mean, I show up to every visit. I feel like it's time to move to the, for me, it's time to move to the overnights. Because yes, I've been the Disneyland dad just because I haven't been able to take him home, and to bring him home would make it easier to to sort of discipline instead of, just trying to find something to do for 6 hours outside the home. And by discipline, I mean like getting him up early, brushing his teeth. Those are things I want to do. And I can't do that. I mean, moving forward with the 8 hours, I'm still not able to do that. I haven't given them a shower in 2 years. I've done everything the court has asked me to do, and I'm asking to move to overnights instead of the 8 hours.
Okay. All right. Thank you.
Yeah, sure.
I appreciate the input from the parties regarding kind of this next step in the evolution of the parenting residential time. A more pointed question is that there was a motion for a parenting plan filed by Ms. Vaughn back in August of 2022. We've been piecemealing it ever since then. It appears. My preference would be to do the following. One, I'm okay with the suggestions as far as kind of a tapered or a gentle ease in with several weeks of 8-hour visits and then overnight visits. However, I want to have a more comprehensive plan in place, a parenting plan, where much has changed since I'm assuming the child was young back then, it's 3 now. Much has changed since August of 2022. So I would like to see proposed orders from the parties of what you feel the proposed parenting plan should be in the future. Kind of looking at kind of a long-term temporary plan until the case can go to trial. So I'll make some interim rulings here today related to visitation, but I want to set a future hearing date and tee it up to the parties that I need to have more information from you of what you feel like what this is going to look like more long-term. So I want to have you submit declarations of what you feel is going to be in the best interest of your child, as far as residential time, holidays, exchanges, all of that information, and then submit those proposed parenting plans with supporting declarations. So just any thoughts on that, Ms. Vaughn?
Yes, so I had already discussed this with Beth. With his dad having Tuesdays and Wednesdays off, and our child will be starting Head Start here, but not before too long. I did mention to her that with him being out of Cowlitz County, that he should maybe be considering trying to get into a position at work where he has weekends off, so that he could maybe get him in the long run every other weekend. But at this time, I mean, I have no control over his work schedule or his plans, but that's what I would like to see.
So yeah, that's kind of what I'm talking about, is that I want both parties to kind of treat this as like a new motion for a parenting plan. You're both going to say, this is the parenting plan I think is the best, and you'll fill out the proposed parenting plan, and then you'll submit declarations of supporting why that's the best plan in your view. And so we would set a date for a hearing, and then kind of have something more concrete in place so the parties can move forward. Mr. Kayoshi, are you comfortable with that approach?
Yes. I do want to say that yes, I am off Tuesdays and Wednesdays, and I've said this to Ms. Beth Fellows. I want to be a father. I want to be a part of his education. I don't think, yes, I'm not downplaying education, but I want to hold off on him going to Head Start so I've lost a lot of time with him. I want to be able to spend some time with him before he starts school, and then I have to work around his schedule with school. It's not required that he go to Head Start. I've told this to Miss Beth Fellows.
So in
I
the
want
proposed
to be able
parenting
to-
plans, I'm asking you both to submit. It has a section of before the children are involved in school, which would be preschool time, and then when they're involved in regularly enrolled in school. So those are issues that you can raise in the parenting plan. So we're not going to decide that today. I'm just saying this is what's going to happen. You're going to submit proposed parenting plans. You're going to submit declarations. I'm going to set a date today where we'll come back and address this and get this clarified, and so the parties can have some concrete guidance. So today's the 24th. I'm looking at setting it to the 28th of February. Does that give the parties sufficient time? Ms. Vaughn?
Yes.
Right, Mr.
Yes.
Kayoshi?
Yes, Your Honor.
We'll come back on February 28th. The parties will have submitted the proposed parenting plans, your declarations supporting each, and you'll have served each other, and I'll have those to review. As far as today's activities, I'm fine with 2 weeks of 8-hour visits. And I know that it sounds like you both have a day off on Tuesday, it sounds like. And so I'm just wondering if the best day would be for those 2 weeks of 8-hour visits, if the best day would be on a Wednesday.
Tuesdays would be best. We're both off Tuesdays. Me and Beth, and I think she related to his dad that right now he gets 11 to 5. We were going to up it from 11 a.m. to 7 p.m. and meet at the 72 exit Love's truck stop.
Mr. Kayoshi, does Wednesday or Tuesday work better?
Yes, Tuesday works.
Tuesday. All right. So the visits will occur starting next week, Tuesday, 11 to 7, and it'll be the exchange will occur at exit 77 at the truck stop. There will be no alcohol or mind-altering substances consumed 8 hours prior, and also not during by any party, and also anybody within the household. And then that will occur for 2 weeks, and then thereafter the overnight visits. What's the proposal there for that to occur on what day? Is it best to occur on a Tuesday afternoon to do the exchange at that time and have a return on Wednesday?
So we were trying to figure that out. Also, it's exit 72, not 77. When it comes to that, I do work Wednesdays, so it would be very hard for me to meet him. I can meet Tuesdays for drop-offs, but then I wouldn't really be able to meet Wednesdays because of work, so I'm not really sure.
What time do you get off on Wednesday?
I work 7 to 4 typically.
So why don't we have the exchange, the overnight exchange occur at Tuesday at 6 p.m. and then the return be Wednesday at 6 p.m.
That should work.
Mr. Kayoshi?
That works, Your Honor. So I'd pick him up on Tuesday at 6 p.m., drop him off, and we meet, and the drop-off is at 6 p.m. Wednesday?
Right, at exit 72.
Yes, Your Honor.
Okay, so 2 weeks of the 8 hours. So next week will be the first week on Tuesday, 11 to 7. There'll be one the next week, 11 to 7. And then the following week will be the Tuesday at 6 p.m. until Wednesday at 6 p.m.
One more question, Your Honor. And that, I'm sorry, that 8-hour visit, I am able to bring him up to Olympia?
Yes. Yes.
Thank you.
Okay, as otherwise, then we'll see everybody on the 28th of February. Any last items or clarifications needed?
Nope, that's everything for me.
No, Your Honor.
Thank you.
Yep. Okay, Ms. Fellows, anything else?
No, Your Honor.
Okay, great. Thanks everybody for your assistance and input. Mr. Florek on January 7th, so he's given notice of today's motion. This is Ms. Florek's motion to terminate the abatement in the child support and also to be able to claim tax exemption. Ms. Florek, I read your pleadings related to the incarceration of your husband, the sale of the home back in a year ago, roughly.
Yeah, I'm still in my office right now. I'm wondering.
Oh, I'm so sorry. Let me step out.
So you're asking that the abatement of the $10 per month be basically rescinded and that the regular child support order of $1,070 be implemented. Is that accurate?
Yes, that's accurate.
Okay. Have you received any communication or any pleadings or documents from Mr. Florek?
Well, I know that he would like to maintain the $10 a month, and that he, like, did you see we went to the ALJ and they didn't have jurisdiction? Yeah. So I know that, yeah, I didn't receive any pleadings, and the reason why I asked for a lump sum is
he's reasonable, like, but his parents who are POA are not reasonable. So unfortunately, our child went to like an ER when they were covered under his insurance, and went to an ER while she was uninsured, and I had to pay out of pocket for that cost, and he agreed to reimburse me some of it, but his parents refused to transfer the money into my name. Like they're just there, yeah. So I don't want to just deal with his parents. I would, and he can't transfer money.
Okay, and so when you're talking about a lump sum, I know that there's an expected release date sometime July 2028. That's tentative. That may happen, may not, depending on good behavior and the like.
Yeah.
Is there a specific dollar amount that you're asking for as far as a
No.
lump sum?
No, just if we could just like, I don't know, prepay it somehow so I just don't have to, like, can we adjust it off that tentative date?
Yeah, it's difficult with child support. I'm not sure if I can order prospectively or, you know, in the future that child support payments be made. You know, there's always, I guess, I've always seen it that it's a monthly obligation, and the system tends to be reactive as opposed to being proactive when it comes to child support, because ongoing needs, you know, things come up, you know, costs need to be split between the parties and the like. And I think that's why it's kind of situated as more of a reactive as opposed to a prospective view of child support. So
my concern is that he'll just, or his parents will file for a modification of child support and use the funds, like as in the ALJ hearing, like his parents loaned his friend $56,000, and then they also put the $25,000 in a CD rather than pay me, right, like give me any money for the kids. And so I'm just worried that his parents will, and then he'll claim indigent. I cannot say that right now.
Yeah, well, and I appreciate that input. That's important as far as dissipation of funds and the like. I was looking at the statute 2609-330. That's basically, it says the child support office needs to review abatement orders before they're approved. And so I'm just kind of curious. Part of that is that they have a duty to review, make sure assets are available to provide support while incarcerated. So I'm just curious if the Office of Child Support should be involved here to lend assistance, since statutorily it sounds like they have some involvement.
Yeah, they just said when I talked to the DS, like the attorney, they were like, you just have to go through the ALJ judge, and the ALJ judge said because it was marked on a superior court order, which because unfortunately I did it, we were like amicable, and I was told by the clerk like I have to mark all the big boxes.
Okay.
So
let me.
I just don't want his parents to. They're like, well, he had to, you know, pay so much for an attorney fee, you know, for his criminal side, and then he had to pay all his medical bills, but my kids shouldn't have to. And then, you know, if he gets sued by the family, like I don't want my kids to have to suffer.
Right. So I'm looking at the child support order. It says $10,070 per month.
Yeah.
And so let me pull up once again just that statute that I mentioned before. I just want to just review that briefly to make sure that child support does not have to be involved, or if we can proceed without them. So again, I'm looking at 2609-330. So when a child support order contains language regarding an abatement to $10 per month based on incarceration, the department, Child Support Enforcement Department, must do the following: review the support order for abatement. Once the department receives notice the person required to pay support may qualify for abatement. That means down to the $10. They have to review records and other available information to determine if the person required to pay the support has possession of or access to income or assets available to provide support while incarcerated, and decide whether the abatement of the person's support obligation is appropriate. So
I thought it was pretty clear too, because I've actually consulted with several attorneys and tried to look up case laws. And so I feel like I'm just getting like ran through the ringer, right? Like I try to file all the appropriate steps with child support. And so they scheduled me an ALJ hearing. And then we looked up the statute, like they don't have the authority to override or like the superior court. And so like I feel like I'm just like in this limbo because nobody knows what to do. So I've not found an attorney that successfully knows how to do this. That's how they told me to kind of file a motion. So nobody, like, because this is a relatively new law of 2021.
Yeah.
And obviously, like, the statute, it shouldn't apply to him because he had assets. So,
Yeah.
but nobody wants to like touch it.
Yeah, I think the appropriate step has been taken. I mean, there's a motion here before the court. I think one of the parties is absent. I think that the one party that is absent is child support, the Office of Child Support. So I think they need to be given notice of what you're asking, and because they have some statutory duties under 2609(330 to chime in on that particular issue. So I think overall your position is well taken. Based on what I've read as far as available assets. What I think would be appropriate is if you could give notice to child support enforcement, we come back and get their input, and then we can finalize things.
Okay, so I just have to contact my child support case manager and then Attorney Wong, because he knew I was going to file something with the Superior Court.
Yeah, I think you'd need to file something on the child support enforcement. Generally, there's a Miss Looney or Miss Powers that appears on this particular docket.
Okay.
And just supply them with a docket notice and a copy of your motion on all the materials that you submitted with your motion, and your motion should be supplied to them. And let's do this. Let's give it come back on. Do you think 3 weeks would be enough?
Yeah, I will. Yeah, I'll have to look at my schedule.
Okay.
Yes, 3 weeks is fine.
So that would be the 14th of February.
Okay.
So we'd be back. So you would give notice here promptly sometime this week. Send copy of those motions that you filed to the Office of Support Enforcement. And you could look up on the Washington State Bar Association website for addresses and contact information of Ms. Looney or Ms. Powers.
Yeah.
And those names are fairly unique as far as, looking on the Bar Association website. So you should be able to find that.
Do I need to reserve David?
He was served for her today. I'll note that he's not present here today. It would be wise to give him notice of that hearing also. Just give him a docket notice and let him know that it's going to
Because it does take the sheriff's office to a while to, because they have a collaboration with Walla Walla. I do talk to him frequently on Securus. Is it okay that I let him know that the date, or do you want an actual service?
So I think a docket notice is appropriate. I don't think there doesn't need to be service per se. He's not here today. There's no indication that he made efforts to be here today. So we'll note his absence, but giving him.
And then, but I could just let him know and then just show the court that I let him know on Securus or something.
Yeah, however you want to provide the notice to him, and then show documentation of that notice.
Okay, perfect.
So we'll be back on the 14th at 9 a.m.
All right, thank you so much.
Make sure you're unmuted. Levi Bondurant, I see you. Can you hear me okay?
Yes, I can hear you, Your Honor. Can you hear me?
Yep, I can. And then I see Ms. Turnbull is present as the guardian ad litem.
Good morning, Your Honor.
Good morning. Okay, I have this, and I'll double check once again. Chelsea Bondurant, if you're on the line, please state your name. Chelsea Bondurant.
Chelsea Bondurant.
Okay, thank you, Ms. Bondurant. Welcome. We're here today, from my understanding, I'll turn to Ms. Turnbull for a little greater clarity, is that there is a guardian ad litem appointment order entered on September 12th of last year and made a division of payment. And I think that's why we're here, is to review that payment, but I'm not quite sure. So I'll turn the time to Ms. Turnbull.
Yeah, I was not there on the original appointment date, but there was a division of payment, and that is my understanding that it was going to be reviewed as well.
Okay, thank you. Mr. Bondurant, what's your understanding of the purpose of today's hearing?
Was that to me, Your Honor? I didn't hear which Bondurant you're speaking to.
Yes, sir, Levi Bondurant, pardon me.
So my understanding, it's complicated because I got two different cases, two different cause numbers on different family law matters. One's on this docket and one's on another docket, same guardian ad litem. So my understanding was, I believe we were going to be reviewing kind of the case at this point. I mean, I think right around 5 months, I think, that I've gone without having, with having very limited access to my children. The last I remember is that we were waiting on evaluations. There was a lack of an evaluation paperwork having been turned in to Ms. Turnbull, and that evaluation has since been handed over to her for her review. So that's kind of where I'm at right now. I'm hoping that we can gain a little bit of traction here, being that I think my kids are being emotionally kind of torn by my not being able to be around the kids for more than a couple hours a week. And honestly, none of my three want to do supervised visits anymore. And yeah, I think if you ask Mrs. Bondurant, she could also agree to that. So if at the very least we can make some minor alterations to what we presently have to accommodate what's in the best interest of my three children, that would be fantastic.
So let me ask, thank you, I appreciate that input. So related to the guardian ad litem order, generally guardian ad litems, they need to be paid to provide that service. Have you provided that payment to Ms. Turnbull?
I believe I turned in the correct paperwork for the courts to pay for it, Your Honor. I believe that was one of the requests that was made in another case.
So the question is, have you made payment?
No, Your Honor, I didn't believe I was required to make payment. I'm notified Ms. Turnbull that the financial declaration would be sent in and that the courts would assist with that, being that I was unemployed.
So I'm looking at the September 12th, 2023 order appointing guardian ad litem for a child. It appoints Ms. Turnbull. And in paragraph 10, GAL fees, it says the guardian ad litem's hourly fee is $67.50. GAL may not charge more than $1,485 without court review and approval. The GAL fees will be paid as follows: 50% Levi Bondurant and 50% paid by the public or the county. So it looks like there's the obligation on you to pay the $742.50. So that needs to be paid. If there's a concern on your end that you can't pay that, then you need to bring a motion in this case asking for relief from that.
3 months later, this is now just being brought to my attention. This was not something that was brought to the attention at an earlier court date, nor the court date prior to that. So I was under the impression that it was going to be waived in this case. So this seems like I'm being kind of like done everything the courts asked me to do and then some, and my kids are suffering because of a lack of payment.
You were present here on September 7th when that court made that order, and it was filed on September 12th. So you were present, and ostensibly you were aware of what was happening.
120 days later, Your Honor. I'm sorry
you
that
were present
I
during the
misunderstood.
time when the court made that order. So it's not something new to you. You were present during that hearing. So my question to you is, one, when are you going to make that payment? Or two, when are you going to file a motion for relief?
As soon as possible, Your Honor, because I've done everything the court's asked in a timely fashion. I was just unaware. I apologize. That is my fault.
Ms. Bondurant, your turn.
Mr. Bondurant is correct in the fact none of our three kids want to do supervised visits. And then doing it at a facility doesn't work with either Mr. Bondurant's work schedule because he works 3 to 11, and then our kids are in sports. And so I've been kind of talking with Miss Turnbull about some options of visits and how to go about that.
Okay. All right. Thanks. All right. So, Mr. Bondurant, if you're asking for relief from making that payment of that $742.50, you'd need to file a motion to basically revise the order appointing the guardian ad litem to change that payment arrangement, because right now it has you listed as paying half, and then the county is paying Ms. Bondurant's half.
Yeah, like I said, I was under the impression, I think that there was a little bit of confusion because I think that I was relieved on one case and maybe not another. I'm not entirely sure. But either way, I'm not worried about the payment being made to Ms. Turnbull. I'm more concerned about there being a further delay, being that we're 120 days past that court date and have literally done nothing in terms of my kids having any sort of relief to this situation. So I will hopefully get in touch with Ms. Turnbull as soon as we're done here and see if we can make some sort of payment arrangements to get payment to her as soon as possible.
Okay. All right, that sounds great. So at this point, I don't think we'll take any additional action. The order's in place, and if Mr. Bondurant wants to bring a motion for relief from that payment or wants to make payment arrangements with Ms. Turnbull, he can. And it's important that, yeah, the case does move along so that the parties can have some resolution to this and have greater visitation or what have you. So that's where we're at. I'm not going to set a review hearing. If the parties want to, once things have been sorted out as far as the payment and Ms. Turnbull is moving forward, then she can submit something to the parties as far as a report based on her investigation, or either party could bring a motion related to any type of relief you're asking for. So we'll leave things as is. Ms. Turnbull, any final comments?
No, that's fine, Your Honor. Thank you.
Mr. Bondurant, any final questions or comment?
Nope. Thank you very much, Your Honor. I appreciate it very much. Have a wonderful
I
day.
have a question, Your Honor.
Go ahead, Ms. Bondurant.
So do we still have court then, February 28th?
Do you know what the purpose of it was for?
The GAL findings? Like this one was supposed to be
This
for?
is yeah, this is what's getting confusing because I feel like this is being misinterpreted by the courts. I apologize, but this was supposed to be some sort of variation of a review hearing today. And it was pushed out 60 days because of a work schedule, because I had requirements to show proof of working, and it didn't comply to that. And then with the snow, then that it was an additional week. I think Ms. Turnbull would agree that this is an excessive amount of time given the situation. I would imagine I've turned over plenty of information here. My kids are actually suffering from this. Mrs. Bondurant is also reaffirming that, but you're not wanting to hear it.
People don't work for free, Mr. Bondurant.
She's been working.
So
she's been to the residence.
Ms. Bondurant, in response to your question, if there is a hearing date set to review the final guardian ad litem report, we'll strike that because there won't be a final guardian ad litem report finished by that time because there's additional investigation that needs to occur and payment needs to occur.
So where do we go from here then?
As I indicated, once payment arrangements have been finalized, then Ms. Turnbull will finish her investigation. She'll file a report, and then either party can note it up for a motion related to any relief you're asking for. That'll conclude the hearing. Thank you. In the courtroom, she's coming forward and taking a seat at council table. Just make sure that the microphone is close to your mouth when you speak. That'd be great. Walker Jackson, are you on the line today? Walker Jackson? All right, Mr. Jackson, if you're here, I can't hear you, so make sure you're unmuted and state your name. Walker Jackson. Okay, there's no response. Ms. Shipper, my understanding is I think we're here to get a status update as far as mediation efforts. Is that why we're here?
Yes, and also about the default, he did pay the 200 to get the default averted. I did receive that payment.
Okay.
So as far as mediation, we haven't gone to mediation yet. I am still waiting for him. So he paid mediation 2 weeks after the deadline.
Okay.
And now it's been 3 days and we're waiting for him to confirm the February 1st mediation appointment.
Okay.
Me and the mediation center are both having difficulties getting a hold of Walker. He hasn't even tried to contact our daughter in over 2 months now. And so it's a waiting game for me right now.
So he's made his payment, you've made your payment, and then on February 1st, what's happening?
That's when we were supposed to have the mediation at 10 o'clock, but they won't set the appointment until they get confirmation from Walker that is okay.
Gotcha. Okay. All right. Okay. Yeah. And yeah, the order vacating looks like that's taken care of and the $200 has been paid. So that's good to hear. So let me ask you this. So you go to, assuming they're able to confirm it with Mr. Jackson and then the mediation occurs on February 1st, then if it's successful to large degree or small degree, then there would be some type of agreement, I'm assuming, hopefully. And if not, then we'd receive word of that also. So usually what happens with these type of cases is that the parties kind of push the case along, right? So if mediation is successful, then you'd come back and say, Judge, mediation is successful. This is what we agreed to. We wrote it all up here on a parenting plan or child support order, and here we all agree. Feel free to review it and sign off on it. If the mediation is not successful, then you would bring a motion to the court and say, hey, we weren't successful, but from my vantage point, this is what I think is in the best interest of the child or the best interest of the children. So you're kind of the one, and Mr. Jackson are the ones pushing the case forward. The court is fine to be a little more, if you will, kind of hand-holding because you don't do this on a regular basis, right?
Mm-hmm.
So I guess what I'm trying to say is that I don't want to be overly involved in the case until you all tell me that you're needing some type of assistance as far as like an order, if that makes sense. So if the mediation goes swimmingly and goes really great and you come to an agreement either in full or in part, then you would submit that order, you draft an order up based on your agreement, say this is what we agreed to, everybody signs it, you submit it to the court and the court signs off on it. So if that resolves everything, great, then you're done. If it doesn't resolve everything and there's still pieces remaining, then either you or Mr. Jackson could bring a motion saying, hey, this is what I want as far as a parenting plan, or this is what I want as far as division of property. And then you'd note it up, file it with the court, give a copy to the other party, come to court, argue your position on the day that's appointed. So that's a long way of saying I hope that the mediation occurs on the 1st. I hope they're able to confirm it. If it's kind of goes by the wayside and nothing happens and you don't think mediation is going to happen, then I think you probably need to bring some type of motion before the court to ask for what you're wanting, since the mediation didn't work out.
Yes, sir. And then I had a question. So this is going to be the second deadline that he has missed, and then obviously he missed court today. What can I do about that? Because he's not showing, he's not contacting our daughter. She had RSV last week and she just got over it, and I let him know, and he didn't even like bother to ask how she's doing. Like, what can I do? Because I'm tired of having to wait on him when I'm doing everything right.
Sure, kind of the same approach. If the February 1st mediation doesn't occur, then you file a motion. You file a motion asking for the relief that you want.
Okay.
Does that make sense?
Yes, sir.
Okay. Any other questions?
No, sir, that is it.
Yes, Your Honor.
Thanks for your patience today. Okay, welcome to you. And Aaron Newton, are you on the line?
Yes, right here, Your Honor.
Okay, all right, Mr. Newton is present and Ms. Lopez is present. Let me just pull up your case notes, one moment. All right, so this is a motion brought by Mr. Newton related to a lot of different things. Signing over a loan, paying debts owed, refinancing, reimbursement of debts, whether there's a committed intimate relationship, engagement ring, overpayment of escrow, cost for development of land, who paid mortgage payments, who paid household costs, the sale of the Rose Valley home, division of home equity, personal property division, and the like. That's why I understand what we're here for. Is that your understanding, Mr. Newton?
Yes.
Okay. And Ms. Lopez, is that your understanding?
Yes, Your Honor.
Okay. Let me just say this at the outset. Motion dockets generally are reserved for discrete, somewhat limited matters. The things that I've reviewed in preparation for today, where it includes almost 100 pages of banking records and a variety of wide-ranging issues, including whether there is a committed intimate relationship, is not something that is generally decided on a short, if you will, motion docket. So, because they're making a finding, if there's not an agreement on whether there is a committed intimate relationship, without that finding, this court cannot make any division of property or debts or the like. So that's hurdle number one. There needs to be a hearing on whether there's a committed intimate relationship. I did a trial last week on whether there was the existence of a committed intimate relationship. It was one day, and other related issues. So I guess what I'm saying, and I'll certainly hear from each of you, what I'm saying is that this case needs to be set for trial on whether there was a committed intimate relationship. And from there, we go to make a determination on whether any of the variety of issues that arise can be addressed. So that's where I'm going, is that, so my thought is it would be set to a universal trial setting docket where basically the date is chosen in the future, and then parties prepare for that trial and then go to trial and make that finding related to the committed intimate relationship. And you could probably take care of everything in that one trial setting. If there is the committed intimate relationship, then all those other issues are addressed related to the finances and the home and the bankruptcy and all those things. So that's my thought initially. So I'll hear from the moving party, Mr. Newton, first, and then from Ms. Lopez.
Well, we broke up January 21st. She moved out, 2000.
So, Mr. Newton, I apologize for interrupting. I wanted to kind of get your input about what I'm saying here today. What I'm saying is that we're not moving forward today, and my encouragement would be for you two to get this set for a trial to make a determination by a court whether or not there was a committed intimate relationship, because that's kind of the linchpin. If there is, then everything else probably follows, and all those things could be looked at and divided. If there is not a committed intimate relationship, this court really doesn't have any authority to do anything with those matters.
Okay. Well, I don't agree that there is a intimate relationship. We've been broken up for years, and boyfriend, girlfriend got engaged. So I would like to fight that if I have to.
So yeah, if there's not an agreement that there was a committed intimate relationship and this precise dates and the nature of it, then that's why we'd need to set it for a trial to make that determination. Does that make sense?
Yes.
Okay. Ms. Lopez, do you have any response to kind of what I was saying about?
Yes, Your Honor. My initial complaint was to be able to establish that there was an intimate committed relationship, and
that the property should be divided. That was my initial complaint. After that, I did receive his declaration and Mr. Newton's motion to sell and have me pay him back. So I agree with you, and I will want to proceed with that hearing and be able to go to trial and prove that we did have a good relationship, that we both purchased the land, we both put time into it, we both put effort, credit, money. So I agree with what you're saying.
Okay. All right. So, Madam Clerk, can you remind me, if you know off the top of your head, when the universal trial setting docket is? Wednesday at 1. Okay. So the universal trial setting docket is a docket in which people who are asking for a trial set or a trial date go to that hearing and they ask, hey, Judge, we need a half day, we need a day. So what I need you to do between now and that trial setting docket, and let's just ask first. So they occur on Wednesdays at 1 o'clock in the afternoon, and they're via Zoom. So I'm looking at the 31st of January or the following week on the 7th. Is there a date preferable for either of you?
I would prefer the 7th. I do not live in Washington or Oregon anymore. I live in Las Vegas, so it would have to be through Zoom.
Okay. Thank you, Mr. Newton. Mr. Newton?
I can go with the 7th as soon as possible.
Okay. Yeah, the clerk just told me that the docket on the 31st is full, so necessarily would have to set it for the 7th. So what I'd ask each of you to do in preparation for that universal trial setting docket, it's helpful for the judge to know some basic contours of your case. So if you have a general idea of your witnesses, the number of witnesses that you would like to call to help establish or disestablish a committed intimate relationship, and then witnesses who have information about mortgage, the sale of the home, personal property, reimbursement of debts, all of that, you'd kind of have a general idea of how many witnesses you'd like to call and a general idea of how long you think how many days or time you would need for trial. Keep in mind, trial days generally are from 9 to 12, so 3 hours, and in the afternoon, basically from 1 to 4:30, so about 3.5 hours. So it's limited. So there's breaks in there too. So plan on about 5.25, 6 hours in a day. And of course, in your calculation of witnesses and time estimates, you would take into consideration your testimony, because both of you would probably want to testify, and you'd probably want to have individuals testify on your behalf. So that's kind of just a heads up that'll help make that trial setting go a little bit better. And on choosing a time, amount of time, so they can find a slot to have the case heard. So we'll set that date on February 7th at 1 p.m. And like I said, it will be via Zoom, and you can find the Zoom link on the Superior Court website on that particular date. Ms. Lopez, do you have any questions?
No, Your Honor. Thank you.
Mr. Newton, do you have any questions?
I wasn't served with any of the recent paperwork I've seen on the website, other declarations and other orders. So I was wondering if I can see that, or how do I get to be able to see that? If I can go down to the court, they'll let me look at that.
So do you have access to what's called Odyssey?
I mean, I can figure it out.
Yeah, Odyssey is the filing system for all court pleadings. So you could check with the Cowlitz County Clerk's office, and I think they can give you direction on how to gain access to that. Generally, when there's, I see, so there was a summons, a complaint, declaration of Ms. Lopez, and a scanned exhibit that looks like was served upon Mr. Newton, possibly. So it's indicated that the documents were posted on his front door at eye level, and then called and notified you that the documents were at his home. So
that I got. That was the first one, the complaint.
Okay.
That's all I've ever received. But I was wondering, since there's more stuff, can I still, like have other people write declarations?
Yeah, and keep in mind that when a matter goes to trial, declarations don't cut it. We need to have persons live testifying. So they would need to be present, and you would ask them questions, and they would share the information they have. So submitting declarations at this point really is not that important. what is important is that a date is chosen, the witnesses are contacted, and they're invited to testify on a particular date once you know the date. Because if you come to court, that's generally hearsay. It's a written document that's made outside of court that's offered to prove the truth of the matter that's being asserted. So generally, that's not going to be allowable. Written declaration is generally not going to be allowable unless both parties agree that the court can consider it. So live testimony from live witnesses is the way you get your information across to the court. And then any exhibits or documents that you want to have presented, you'd prepare those.
Your Honor, I filed my response on February 12th, Friday, February 12th, and I emailed Mr. Newton all of those documents on Saturday, February 13th. I do have on one of the forms that he served me saying that it was okay for me to email him any further documents that I filed with the court. So on Saturday, February 13th, I emailed him that, and then I also texted letting him know that I had emailed him all that, and I never got a response through email or text. So I'm not sure if he received it or not, but that was served to him.
No, she's been blocked off me for some time now. I didn't want to be harassed anymore.
Okay, so sometimes parties can agree to allow for electronic service or email service. If there's not a specific agreement, then it has to be kind of the old-fashioned way through mail, U.S. mail, or personal service. So
on that paper.
Go ahead.
Sorry, on that paper where that I received saying that I was allowed to serve him in that email, that the box was checked, and it was the email that was on there, and that's where I served it. So if I'm blocked, then I mean.
Yeah. So if there's any future documents to be served, have to do it kind of the old-fashioned way.
Okay.
Through mail. All right. So February 7th, 1 p.m. trial setting docket, and you'll be prepared give the court kind of a general estimate of the time needed to resolve the issues.
Thank you.
Thank you, Your Honor.
Thank you. Ms. Height is present. I look like she turned on her camera and shut it off quickly, but there she is again. And so she's present, and I'll ask if Shanice Hastings is on the line.
Yes.
Okay, welcome to you, Ms. Hastings. And does your camera operate?
For some reason, let me see. Okay. I have really bad service right now. I'm up in like the boonies and my internet sucks.
Okay. All right, that's fine. And then Brandon Lovato, are you on the line?
Yes, Your Honor.
Okay. Welcome to all of you. We're here for a review of the final guardian ad litem report. And my note here says that I don't. Looks like Ms. Height was appointed in August, late August of 2023, if that sounds right. And I'm not sure. My first note here, I took a lot of notes, but then my first note says that I don't see a report that's been filed. So I'll just double check with Ms. Height.
My report was filed, Your Honor, on January 2nd, 2024.
Oh yeah, there it is. Okay, I think what I did. Let me make sure this is the one I read. Oh yeah. I read this one. I read it. So I didn't go back and fix my note. So I have read the report, so I appreciate that. Thank you. So let me ask the expectations of the parties here today. So we have this guardian ad litem report. There's the issue with the children living in Alabama or living in Washington and the like. Is it the anticipation of the parties that we would hear from Ms. Height and just highlights of her guardian ad litem report? Each party would have an opportunity to respond and give your impressions of, and then are the parties anticipating that the court would make a decision today related or based on that information and the information filed in opposition? I'll ask Mr. Lovato first.
Yes, Your Honor. After receiving the report, I kind of went through it, and there was a lot of discrepancies and a lot of objections to the report, as well as with the notes that I received last night. And I was looking to try to get an investigator appointed to it to ask the girls down here in Alabama to have more contact and build more rapport with the girls, to ask some of the questions that were initially addressed in in the earlier court dates, as far as some of the contact that was going on in Ms. Hastings' home. Because in the notes from the GAL and the report, none of those were addressed. And so I was looking to get those addressed before we move any further.
So from your standpoint, you're asking that the court not make any decisions today, but allow for a separate investigator, provide a report, and then come back at a later time and make some decisions?
Yes, Your Honor. And if allowable, one that's local here in Alabama, that will be appointed by the court so that the girls will have in-person sessions and have access to the home and conduct in-person interviews with myself as well.
Okay, thank you. And Ms. Hastings, what is your anticipation from today based on the information that's been addressed in both Ms. Height's report and Mr. Lovato's response? Are you anticipating that there would be decisions made related to the whereabouts, the living, where the kids live, or what happens?
Yes, I was hoping that today we would come up with a solid plan because my girls have been drugged through the ringer these last couple, well, it's been about 2 years now, almost 2 years now. And I mean, we have proof of Brandon manipulating the girls, and the reason why he is saying the things he's saying because he's not liking what, and did a very good thorough investigation with my girls, myself, and Brandon. And he just doesn't like the outcome of what she found. And we have proof, many videos, proof of everything that's been said to be true in her report. And for prolonging all this is just hurting my kids even more.
Okay, all right, thank you. And Ms. Height, just kind of from a historical perspective, is with your appointment and the setting of the review of your report today, was it anticipated, at least kind of contextually, that there would be potential decisions made today related to the children's whereabouts, where they live?
I expected that there would be some decision, Your Honor, yes.
Okay, all right. Mixed in with all this is Mr. Lovato's motion. It's an ex parte motion for immediate relocation that was filed, I believe, on the 22nd of January. So since that's a motion that's brought ex parte, Mr. Lovato indicates that there's no need for notice to the other party. I think that I'm going to deny that motion because the whole issue of why we're here today is squarely that issue, is the relocation. And to have one side excluded from that calculation strikes me as unequitable. So I'm denying the motion for the immediate relocation. This is an issue that needs to be decided with the input of all parties. I recognize that there's water that's gone under the bridge. I recognize Commissioner Baldwin allowed a temporary placement or stay in Alabama with the girls, but this is an issue that needs to be addressed more fully than just on hearing from one-sided view.
Yeah, Sean. I got counsel from a lawyer and said she requested that I did that immediately since there was an issue with procedure. And
okay, all right. So
by the way, that wasn't really a big deal for me at all.
Okay, all right. So I just need to give myself a little note to make a written order of denial of the immediate relocation. Okay, so in preparation today, I read Ms. Height's report. I looked over the file, and I also read a number of declarations from Doug Borgen, Teresa Borgen, a bunch of text messages, some additional emails between, and then also phone records. I also reviewed Mr. Lovato's declaration, and 2 of them looks like, and then a proposed parenting plan, and then that motion for an ex parte motion. So let me just ask Ms. Hastings, did you receive copies of those documents that I just mentioned, like the declarations from Doug Borgen and Teresa Borgen?
I did through email. I actually did respond to all of those, and I did mail 2 declarations, but due to like the snow and stuff, I wasn't sure if like you guys have received it yet.
Yeah, I have not. I have not received that information. So why don't we approach it in this way? I'll give Ms. Hastings leave to provide information that's contained in those responsive or reply documents, and we'll hear from Ms. Height to just a kind of a high level the important points as far as your report, and then we'll hear from each of the parties, and we'll make a decision today.
Okay, sounds good. I'm going to actually just, if you don't mind, read my declaration that I was mailing in.
Yeah, that's fine. When it's your turn, you're free to do that.
Oh, perfect. Okay.
Okay, Ms. Height.
Thank you, Your Honor. Briefly, this is, as Your Honor undoubtedly noted from my report, this was a high conflict case. There's been a lot of response to that. The difficulty at the end of the day in all of the he said, she said, various things that have gone on historically, and there was a lot is that the picture that I tried to paint for your honor was that this has just been like a little battlefield for these children. And I grew more and more concerned as I went through the information that I received in various ways that these girls who are 14, 11, and 8, I believe, have been included inappropriately long term, and this has been damaging to them. And so in an effort to get to the bottom of things and get to what would be the best, I tried to discover what would address all of that conflict in a way that would minimize it going forward. And that's the direction that my report took. As you probably noted, Your Honor, my conversations with the girls on the phone and then my in-person visits with them when they were here in town for the holidays, they were good conversations for the most part. The phone conversations were necessarily brief. Their answers were quite terse. Maybe terse isn't the right word. They were often single replies, single word replies. When we talked here, each of the 3 girls could talk about things that they liked in Alabama, things that they liked in Washington, things that bothered them in both places, problems in both places with mom and with dad. At the end of the day, one of the children said, "I just want to be a kid," or words to that effect, which I felt encapsulated where we needed to get in this case. I attempted to make a clear picture of what I felt the court needed to know without unduly going down a lot of old history that didn't apply in the issues that I was trying to get to. What I came back to over and over as I struggled putting this in the clearest way that I could for your honor was that the girls said, "I like dad, I like mom, I love dad, I love mom. Dad does these things that bother me, mom does these things that bother me." And they were just, I think I used the word ambivalent in this report more than I ever have in a report. They just have been left to kind of fend for themselves to make decisions or recommendations. And every single time that I spoke with them about what they wanted, I tried to be meticulously careful to let those girls know that I don't make the decision, they don't make the decision, but that I would clearly let the court know so that the court could make the decision. Because I wanted them to know that they could speak clearly to me, but I wasn't going to make any promises one way or the other. Even giving that, they were back and forth, one time this, one time that. So at the end of the day, I weighed everything that I had, knowing that this is high conflict, knowing that it is awkward to move children. There's going to be drama either way. Our decisions that the girls are now making, they're paying for those decisions that have been made. So I attempted to write the clearest report I could for your honor. I stand on that report. I think my recommendations are what are in the best interests of Courtney, Kaylee, and Bailey at this time.
All right, thank you. All right, if I could hear from Ms. Hastings, you're the petitioner, and then Mr. Lovato, you're the respondent. So let's go in that order.
Okay. Is it okay if I read my report now?
Sure.
Okay. So this was just in the response to his declarations that he submitted to the court. His mother, Teresa Borgen, his stepdad, Doug Borgen, and himself. So I didn't want to bring in, because he keeps bringing up stuff that's just not relevant to our children. I mean, a lot of this stuff is just like, it's just stuff that just doesn't even need to be in reports. It doesn't even need to be talked about because it has nothing to do with our children. But I wrote, I declare in the GL report, Teresa Borgen stated that I had multiple personality disorder and a bipolar disorder. This is not true. She states when I was 14 or 15, I was diagnosed with such illness. I have never been diagnosed with any type of disorder in my life. I'm trying to pull my medical records, which it's a process. It's from I guess you have to go to the place that I did all my medical when I was a child, I guess no longer even exists. So I'm still in the process of even trying to figure that even out. Okay, let's see, where was I? Medical records to prove and debunk that rumor. It's wild to me to have anyone bring up something of such nature after knowing me for over 16 years and just now hearing of such medical diagnosis I've never even heard before. I've always been the primary parent to care for my children. When I was married to Mr. Lovato, I was deemed a fit parent to Mrs. Borgen's standards. All this medical stuff is new talk since the divorce and very untrue. Another thing in the report that I'd like to touch on was another rumor from Mrs. Morgan. She states, I told my children, Kaylee, that if she was not good, then I'd miscarry the baby I'm now carrying. I don't know anyone in their right mind that would say or even come up with such a wild statement. I simply told my children I was pregnant instead of it being a happy time for my children. Now Mrs. Morgan is turning into something disgusting that's never even happened. One of the girls overheard a phone conversation with my doctor telling me that I could be miscarrying because I was spotting a little bit. Overheard a phone call to my doctor telling me I could be miscarrying, but that was never told to the girls directly ever. Brandon emailed me his declaration and in his report, there's tons of misleading things. One of those things he states he does not use cursing to discipline our children. I have video proof of him using vulgar language with our children that I have shown Ann Hyde. He has shown our children text messages and videos of myself and my husband behind closed doors that no child should ever see or have to witness. Brandon hardly has our two younger children, as he pawns them off with his mom almost daily. And when I ask my children where they are, 9 times out of 10, they tell me that they're at their grandma's house. I think Anne did an amazing job with her report and really listened to what my children had to say. My husband also wrote a declaration, but I don't know if you want me to read that one. It's just all the rumors that are going against him.
Probably not necessary.
Okay.
All right. Thank you, Ms. Hastings. Anything else?
In the 2 years that we've been going through this now, it's been multiple. The last time we actually saw you when we were in your courtroom, we were agreeing on the girl staying with me full time and then going to him in the summertime. And that was our last, court hearing that we were supposed to, put in a parenting plan and sign and stuff. And then since he didn't like the fact that I wanted my youngest daughter, Kaylee, coming back to live with me, he then came and did a full 360 and turned the entire case the next time we went to court. And then that's where we are now. And that's just where we are now. So in reality, none of this really is about the kids. It's about Brandon trying to use these kids against me and hurt me. It has nothing to do with these kids. It's just not.
Thank you, Ms. Hastings. Happy to hear from Mr. Lovato, please.
Yes, Your Honor. A couple of things off of her district sponsor report. I've never shown any text message or videos or audio clips to our kids, never once. And the fact that this was also one of the other many things that I've never been asked for clarification or even talked to about the girls through this process of this investigation, along with many other things that initially brought my concerns to the court to keep the kids down here. None of that was ever addressed. Through the notes that I received from the jail last night that I read through, they document the exact same thing as what my kids were being asked by their mom after the first initial phone call at the jail, nothing was asked of her and her conduct, only of mine. And like I said, the reports and the notes both facilitate that, and then has nothing to do with her conduct at all. And that was the main reason, like I said, to even have them here with me. I did initially come down here to Alabama just to get away to clear my head from a lot of stuff that was going on, and I did decide to make this a permanent move. And there was initially, me and Shanice came to an agreement when Kaylee became too much for her, that Kaylee was going to come down here and stay living with us. And I sent the text message to the court showing that she did agree that Kaylee was to stay down here, and even offered Kate or Courtney, our oldest, because they were both having issues up there with Shanice. The issue became a problem, and Shanice went back on her word saying the girls can stay down here, is when Bailey, our middle daughter, decided she also wanted to stay, and I didn't want to separate the girls to begin with. But because of a misunderstanding of how things work with the courts, then we all thought the girls were able to decide kind of where they were, and the court said, no, that's not the case. But when Bailey told her mom this, immediately her mom started yelling and screaming at her, saying, and verbally and emotionally abusing her, saying, if you really love me, you wouldn't ever say this. You wouldn't ever want to live with your dad. You wouldn't want to stay in Alabama. How can you dare say this if you love me? And that caused a lot of problems. And Bailey was freaking out, crying, saying, I'm sorry. And that's what led us to, along with all the conduct that the girls were telling me, and even our oldest was telling me about what was going on in the house while I was down in Alabama. That is what led us to require a GAL. And that is why I requested a GAL. This is the second time I requested a GAL. And as far as the girls being down here, they've been doing amazing down here. Initially, there was a few issues with Kaylee going to school because she does not handle transitions like that very well. So going to the school by herself and doing all that, she's been doing great now. She's excelling. All the girls are doing good in school. There was some issues with Courtney with the truancy issue. and it was 4 days were missed because of an ER trip, and she had some time off from the ER, and that slip didn't make it into the front office. And there was also 2 days missed from when Miss Hastings came down and visited the girls and had them out of school. So outside, if you took the issue out there, all the girls aren't missing any days other than 4 appointments. That's the only time they're missing any school days. They're all in counseling again. This is the second time I've had them in counseling, and they're all starting to finally get their feet on the ground here. They don't want to move and go back and forth. They all have said, yes, they do want to live with mom and me. They all would like to be closer, but that's just not something that right now is possible. My oldest said that she would prefer to live in Washington, but that is only to be living in Kelso, Washington, not Blaine, Washington. And she refuses to move back with Shanice if her husband's there. I sent the text messages to the court showing exactly what she feels about Mr. Hastings and the conduct that goes on. And this is just the newer stuff that I found out about, with him walking around with erections and then talking about sexual jokes about their sex life in front of the girls, and talking about shoving a tampon into Miss Hastings. This is the kind of stuff that's constantly going on. It's been a repeated issue. There's declarations in the past about the same conduct, and it keeps coming up. There's a promise that it'll never happen again, and here we are again with the same stuff going on. And these are the concerns that I sent these exact same emails to the GAO and said, this needs to be investigated. This needs to be talked about, please. And like, this is absolutely disgusting. This shouldn't be going around the girls. And none of it ever got asked. None of it's ever been investigated. And this can't be going on around the kids. And the fact that my oldest is completely creeped out by Miss Hastings' husband and does not want to live there, does not want to be around him, doesn't want anything to do with him, don't even want to hear his name being said. Returning her into that environment is not going to be beneficial to her. Moving the girls, all 3 girls, back to Washington into a new environment, a new city, a new school isn't going to be beneficial to them. They're starting all over again. And Miss Haight is right, and she's right. These girls have been through everything back and forth, and myself and Miss Hastings are to blame for that. We've let our own personal feelings get in the way of a lot of this, and the kids have overheard things and been involved way too much. And I do agree that this does need to come to an end, but I don't agree that they return to the Washington under this context. When Shanice has her own new family started, she has a brand new baby. She's 4 months pregnant again with another new baby, and living with her husband, who is now back active military, who in 2 years can get orders to get moved across the country. That's not stability. And if that's the main reason for this, stability is with me. I'm not planning on moving. I'm staying in this school district, and the girls have every chance to thrive down here. And sorry, Your Honor, but these girls are everything to me. They are everything I hold dear in this world. And the fact that I keep getting asked, this is just a mere thing to hurt her. No, I want my girls. I've wanted my girls. I've wanted every morning. I want to be there with them. Every night I want to be there with them. That is all I've ever wanted. And the fact that I keep getting told that, no, you're just trying to use this to hurt them, or you're trying to do this, or you do that. Yes, I do yell sometimes at my girls, and I have to because they get loud, and I'm not trying to yell at them to scare them. Yeah, I raise my voice to get their attention because they do fight and they do have a lot going on. And I don't hit them. I don't threaten them. I don't verbally abuse them. And I do realize that, yes, I do cuss sometimes. And yes, it's been something I've tried to work on, and I don't use it. I use it like someone would say the word and I know it's bad, and I try to work on it, but it's not used at them. It's not used to discourage them. It's not used in a derogatory way at all. I've been fighting for my girls. I've been fighting for what's best for them, and I believe wholeheartedly that what's best for them is here with me, Your Honor.
Your Honor, can I actually play a video just to debunk everything he actually just said in that statement, with him not using vulgar language to my oldest daughter, cussing her out? We actually have a video proof of him doing that exact same thing to my oldest daughter, and her telling him to get out of the car, and him basically cussing her out.
I'll decline the invitation of watching the video. Thank you.
Yeah, it's pretty upsetting. It's very upsetting.
Okay.
And everything he said about my husband, I mean, Anne's done many reports. She's talked to his family, his stepmother, and got his character. He's used to work with children at the juvenile detention in Cowlitz County. He used to be a detention officer there. He had to pass numerous polygraph tests. He's had to do many different psych evaluation testing to even get jobs in that field. And to say my husband is doing these outrageous things with no proof it's just very disgusting. I mean, I mean, to say a man is doing these things, but then him having sex on a couch next to my children is kind of, I mean, my girls told me that their dad had literally had sex with one of his little girlfriends when they were next to him. So, and they walked out on him having sex on the couch. So, I mean, him saying all these things about my husband, it's like, we can go down that rabbit hole and doing pointing back and forth, blaming and all this stuff. But it's just like, how is this helping our kids? And my girls were actually here on Christmas. Courtney wanted to come, knowing my husband was here, wanting to still come and say, be here for the week. They were here for like a little over a week and a half. Nothing out of the ordinary happened. She still came out and did family things with all of us, all the children, including my husband. So to say that my daughter, I mean, in the very beginning, yes, when things were first happening, she was getting jealous because she wanted it, for her understanding, she thought when I left her dad, it was just going to be me, be single and then be with all the kids and us just be us. And that's what she wanted. But then it didn't go that way. I got married. And so she kind of was like, more like, it was a jealousy thing. So, and that's where that was.
Thank you. I wanted to ask Ms. Height just a brief question, if I could, regarding the oldest daughter and her comfort level with Ms. Hastings' current husband.
When I spoke with her, I had received some reports that some of what you've heard here, that she couldn't tolerate being around him. And so after we had talked for some time and I felt that she was pretty comfortable with me, I asked her about that. And what she told me was that she was very vague. She didn't specifically say anything about feeling endangered by him. What she said is, he jokes around, he's just like a big kid, was kind of her big issue with him. And I did not feel comfortable pursuing any kind of sexual questions with her, but the open-ended questions that I gave to her, she did not respond in a way that made me feel that there was anything that was concerning enough for me to include in a report. Her issue with him was more of a personality issue than anything else that I could discover.
All right, thank you. All right, so procedurally, this case is, I'll call it irregular, in that there was a move to Alabama with the girls for a period of time that was kind of later temporarily ratified by a court commissioner. And so what I'm treating this is as a motion to relocate, which necessarily requires me to look at statute, and there's factors that the court uses, and this is based in 2609-520. So I'm looking at a parenting plan that was issued on March 9th of 2023 that names Ms. Shanice Hastings as the custodial parent, and then it provides for a week on and week off to each parent. Basically, it's that 50-50 arrangement. So this is March. Much has changed since then, but this is where we're at. That's the most recent parenting plan that I've discovered. So under the statutory rubric, Ms. Hastings receives a presumption that if she wants to move, then she can move. And then Mr. Lovato is in a position to rebut that presumption by demonstrating that the detrimental effect of the relocation outweighs the benefit of the change to the child and the relocating person. And then there's a 11-factor test. So
if I may talk on that part, my husband is stationed here for 4 years, and after that, he's getting out of the military. We're actually going back to Cowlitz County. We're only 3 hours away from Cowlitz County right now, and we go there pretty frequently. My family's there. My kids have all their support system they possibly can ever need. They have cousins that they're very, very, very much close to. When in December, when they were here, my 11-year-old Bailey, she is very close to her cousin British. And they actually were so distraught because they hadn't seen each other for months because of them moving to Alabama. And so they both were breaking down crying and not wanting to let each other go because they knew that Bailey was having to go back to Alabama. So these are the things that are happening because of them being in Alabama. And I have no plans on leaving Washington ever in my life.
Thank you. So that presumption, as I indicated, goes to Ms. Hastings. She's not relocating here. It's Mr. Lovato that's relocating, and it's, like I said, it's procedurally irregular in that he has basically custody of the kids in Alabama right now after kind of an extended stay that turned into even a more extended stay. So whether or not that presumption necessarily applies and how it's worked out, There was a relocation of Miss Hastings from the local area to northern Washington, Blaine area up by the border with Canada. But that's not the relocation we're talking about. The relocation we're talking about is the Alabama. So I'm just going to review the factors in that relocation statute and just to discuss it. So the first factor is the relative strength, nature, quality, extent of involvement, and stability of the child's relationship with each parent, siblings, and other significant persons in the child's life. Here we have three girls, and it sounds like they love both mom and both mom and dad. They love them. They want to please them. They want to make them proud, and they're caught in the middle. And it's very challenging for them. But from my sense here is that you've got a 50-50 plan. 50-50 plans generally are indicative that pretty good relationship between parents and their children. I think what has occurred since that time is that things kind of erupted, and maybe the children have been involved inappropriately in the situation. And anytime that happens with kids, they always take it on the chin and are really the ones that are really damaged the most, since they're least equipped to handle that emotionally. Nonetheless, I think Ms. Hyde indicates there's kind of this sense of ambivalence, or kind of this back and forth between, I want to live with dad, I want to live with mom, and the good and the bad at mom's house, and the good and the bad that's at dad's house. And so what strikes me is I think that the girls have a good relationship with each of the parents, that both parents have been involved with their children. I mean, certainly each party can quibble with that statement. I'm sure there's much to be discussed there. As far as prior agreements, Mr. Lovato indicated that Ms. Hastings at one point said, at least with one of the girls, probably be a good idea for that particular daughter to stay there for a particular period of time. Obviously, that agreement is not sustained at this point. And then it talks about disrupting contact between the child and the person seeking relocation, which I'll deem Mr. Lovato here, would be more detrimental to the children than disrupting the contact between the child and the person objecting to the relocation. So it's talking about kind of a continuity of relationship between the children and the parents. Here, there's a huge physical distance, geographic distance between the parties. Over 2,000 miles. Alabama to Washington is not a quick trip. There's significant costs involved in traveling to and from, especially when you have three daughters. So if the relocation remains in Alabama with dad and the girls, that necessarily disrupts the contact between mom and the daughters, because people just generally can't afford to fly cross country every couple times a month, or even once a month. It's cost prohibitive, I think, for most. So there's that potential for that disruption of contact. Also, there's the potential for a disruption of contact if Mr. Lovato stays in Alabama and the children in Washington. Then there's a similar concern that his contact with the children would be disrupted. My understanding that the next factor is whether any of the parents are subject to limitations in the parenting plan. When I looked at that parenting plan earlier, I didn't see any limitations. Basically, it says does not apply. So that factor is really not there. Then the next factor is the reasons why each person is seeking or opposing the relocation in the good faith of each party, and the parties requesting or opposing the relocation. Here, it sounds like Mr. Lovato is, I think it's his mother that lives in Alabama with her husband. They have a house, they're living there. Cost of living is less expensive there. And he wants to, it sounds like good schools there and the like, and he wants to live there. So I don't find that there's any bad faith. It seems like there's, he had to, at one point in time, he had to kind of clear his head and just get away from the situation. That may not have been the most wise decision at the time, but that's kind of water under the bridge, and here we are. Ms. Hastings, similarly, the reasons for opposing the relocation to Alabama seem to be made in good faith also. So the children are, in pretty critical, pretty critical year, especially at age 14, where people are getting older and they're independentizing, if you will, if that's a word, becoming more independent, pushing against parents a little bit, which is just a natural developmental stage that they have to go through. And then 11 and 8. So tender ages, important ages. And children at that age, even though they're pushing against their parents hard, they need their parents probably more than ever. And I think that's important to recognize. And if the parties being separated by 3/4 of the breadth of the nation really prevents having both parents be really involved with their children and meeting their needs, because clearly all of these girls need both of their parents, because you both provide unique qualities and input that they need. Education-wise, there's much made ado about differences in rankings of schools and the like. I haven't heard anything of that from the parties. I think for the most part, if a child has good support from their parents, that they can excel educationally no matter where they're at. I think that parental involvement is the key and is the foundation to a child doing well educationally. Physically, it sounds like the kids are doing fine. It sounds like they're getting some good emotional support with the counselors in Alabama, which is important. That type of emotional support with all that's going on. It sounds like the parents are really struggling to work out these issues, and having that support is important for the children. Is that available in Washington as well as Alabama? Yeah, I think so. A professional credentialed counselor can provide that necessary support for the children. I didn't hear of necessarily any special needs of any of the children. So the next factor is the quality of life, resources, opportunities available to the children and the relocating party in the current and proposed geographic locations. Like I said before, I think that for the most part, when we have parents that are engaged in the lives of children, then there are resources available no matter where you're at. Some resources may be better for particular needs from a child. If a child's really into taxonomy, and then there's this amazing historical museum that has all these stuffed animals, and that would be great for them to live there if that's, they've got a scholarship lined up or something. But for the most part, I think opportunities can be created almost anywhere where anybody lives, and without a really strong showing that one location offers these amazing alternatives compared to the other, I think that's kind of a wash. The next factor is the availability of alternative arrangements to foster and continue the children's relationship and access to the other parents. So if the children were to remain in Alabama, what would be the arrangements to allow Ms. Hastings to continue to build that relationship with the children? It's limited, it seems to me, in that there would be potential Zoom calls, phone calls, and the like. Certainly that has its clear limits. Also, I think there's a cost prohibition of traveling with any great frequency. So necessarily, I don't think there's any really good alternatives to really kind of foster and continue relationships with the children staying in Alabama. The next factor is alternatives to relocation and whether it's feasible and desirable for the other party to relocate also. So there, the question would be, would Ms. Hastings move to Alabama so she could be closer to the children? It sounds like Ms. Hastings has a husband who is involved in the military, and military folks are not free to move as they want to move. They obey commands and they follow what their commanding officer tells them. So that's really not an option. The other option would be for Mr. Lovato to move to Washington. Mr. Lovato lived here in Washington for, it sounds like, a very long time. This is where it sounds like where the children were raised, but then just kind of needed to get away and move to Alabama. Apparently, if I understand correctly, he's living with his mom and her husband in their home. So he's not tied into a lease or a mortgage.
Your Honor, no, I've had my own place down here since the girl's been down here.
Okay, so you're renting someplace?
Yes, and I'm still locked in my lease for another 6 months.
Okay, thank you for that correction. I appreciate that. So Mr. Lovato has that lease for another 6 months, and so it kind of begs the question: is it possible for Mr. Lovato to move back to Washington, where the children could have closer access to both parents? To me, that seems like a feasible alternative. It may not be the top interest, and I recognize there's good grandparent support from Mr. Lovato's mother and her husband. So I note that. I also note just that the next factor is the financial impact and logistics of relocation or its prevention. So there are some definite financial impacts that there would be financial impacts to both parties for travel. If the children stay in Alabama, there's going to be some significant flight costs for the children. And children generally don't fly unaccompanied, especially with an 8-year-old and 11-year-old. They can at some certain ages, but there's going to be likely one parent flying out, picking up the children and flying back. So you're talking about the cost of 5 flights. 6, 7, 8, well, a lot. It's expensive. So back and forth, it gets really expensive. And then it's the logistics of allowing the relocation. The logistics there is that basically the girls are there for the most part, so it's pretty easy to leave them there because they have their things, they have their current contacts and friends and the like. And if that were to be prevented, then the children would be uprooted and moved back to Washington and be re-enrolled in a different school, different surroundings, and the like. It's Washington and Alabama. I think some of at least one of the declarations talked about Washington being a certain ideological slant and maybe Alabama being a different ideological slant. And then the last is for a temporary order, the amount of time before a final decision can be made at trial. So in my mind, this is a motion for relocation. It's a temporary. Relocations are decided at trial. And a motion for a relocation is temporary in nature unless we're at trial. So the decision related to the relocation is a temporary one until the matter can be heard at trial or the parties come to some type of an agreement. I think I read carefully the guardian ad litem report where it elicited information from one side, received information, checked with the other side, and received that information, digested it, and shared that information. I recognize the guardian ad litem reports. You have to, at least my experience with them is that they're limited in scope, there's limited time, and information that seems reasonably available and just easy to get. People wonder, why doesn't the guardian ad litem go out and get that information? Go get those medical records and the like. Really what the guardian ad litem is, their time is limited necessarily, and that's for better or for worse. And the guardian ad litem takes the information that the parties provide them. And there's not a lot of extra time in the allotment to dig deeper or dig more fully. And that's a limitation of the system, and that's kind of where we're at. So time before a final decision can be made at trial, the trials are probably being set 6 to 12 months out. Kind of depends on the length of the trial. Shorter trials go out a lot quicker, longer trials take a lot longer to get set. So having reviewed all of those factors, here there's not necessarily a presumption, as I said, that the presumption would necessarily go to Ms. Hastings as the custodial parent, even though there's this 50-50 arrangement in the parenting plan. But I think taking all of those factors into consideration, just taking a quick look at some final notes. Here, I think that there is, if the children were to remain in Alabama, there would be significant detriment to their relationship with their mother. And I don't think that's appropriate given that the factors in that relocation statute. So I'm going to order the children be returned to Washington, because I think there's a strong possibility of that Mr. Lovato can relocate. And to me, that's kind of a key piece here, is that there's not necessarily, my understanding is he's retired, that he's not necessarily tied to a particular career there. He may be engaging in some type of work, but there's not something that's really tying him there. So I think that's a significant factor to allow for the fostering of the relationship between the girls and both parents, because if they remain separated, at least on a temporary basis, the relationship between the children and both parents is going to suffer. And I think what's encouraging to me is that the parties had a 50-50 parenting plan. At one time, the parents were able to work through a lot of issues together, is my sense. But then things kind of blew up. Hopefully, there can be a regaining of that stability and co-parenting. I'm not sure if it can, but hopefully it will. So I'm not permitting the relocation of the daughters or the girls to Alabama. Rather, they need to be returned to Washington. We'll need to talk about dates and times and how that's going to occur. And that I think it's also, like I said before, that it's important for under those factors that I've reviewed, that I think it's that the detrimental effect of allowing the children to stay in Alabama is not outweighed by the change back to Washington. So that'll be my decision. So we next need to talk about dates and the like. Ms. Height made a recommendation as far as a time frame for that proposed move to occur. Indicated that the children are fairly resilient and they've suffered through a lot of drama and awkwardness and the like. But sometimes when there's been injury, sometimes the Band-Aid has to be ripped off, which also causes pain, unfortunately. So Ms. Height, could you just review for me your proposal, and I'll hear from both parties about their, as far as timing and the like.
My recommendations were, as you said, to not drag out a change. I think that would be unduly hard for the girls. So my recommendation was that they return by February 15th and that they have a couple of weeks to get reinstated in school here. And then that they also, within a couple of months, I think I said by April, that mom has them engaged in some counseling. I think that's a critical piece, whether they're in Alabama or Washington, that they have someone they can talk to. So I'm
April
looking
1st,
at February.
April 1st counseling? Or March? Wasn't quite sure.
It was April, I believe. I'm looking at that right now. Yes, that she investigate options and schedule evaluations with the counselor by April 1st and report that progress to father.
Okay. All right. Thank you. I'll hear from Ms. Hastings and then Mr. Lovato as far as timing.
Yeah, I actually have already been in contact with some counselors here in the area. They just said that they have to do like a sit-down consultation with each of them before they can like put them on the books.
Okay. Okay. Mr. Lovato?
There is a possibility for me to be able to return. And if I were to return, it would probably be back to Cowlitz County because I do have friends located in the area or possibly closer to Centralia. And if that would be the case, would it be permissible for the kids to remain with me for the next few months until I can make arrangements to move back?
It's a good question. It's a valid question, Mr. Lovato. From my
Just to
understanding,
return them back into the schools in Cowlitz County.
repeat that again, please.
So that, because that way they could return back to the schools in Cowlitz County, since that's where they were supposed to be going back to initially, and that's where they know everybody as well, and their family's closest to.
Right.
Since I can move back, and I can move back to that area where, again, Mr. Hastings and Miss Hastings cannot move. They are stuck in Blaney for the next 4 years.
That's actually that's not true because
So, Ms.
my
Hastings,
husband.
Ms. Hastings,
Yeah,
I appreciate your desire to provide input. I'm going to just cut you off if you don't mind.
Yes, sorry.
So the Mr. Lovato raises the question of whether basically the return could be delayed. So I'm going to say no. I'm going to hold off on that because there's the relationship issues are I think there's detriment when both parents are not in close proximity to the children, and to delay that till June, July, I think further exacerbates that issue. So I'm going to deny that request. So February 15th is the date that's been proposed, and that's roughly 1 to 3 weeks and a day for the children to be relocated here to Washington State. So any further comment on the school enrollments 2 weeks after and counseling by April 1st? Mr. Lovato, any further comments?
No, other than, like I said, I just know it'd be easier on them if they were returned to Cowlitz County, and it would help with this thing because they're not going. I know, especially our oldest does not want to move to in that direction at all, and especially living with Miss Hastings' husband.
Right. Okay. I appreciate the input. There's a lot of fallout from the decision, obviously. So the girls will need to be back in Washington State by February 15th to reside with mother. They'll need to be enrolled in school by no later than February 29th. They'll need to be enrolled in counseling no later than April 1st. And it sounds like there's some groundwork for that. So that'll be the court's order. I'm going to prepare an order denying the temporary relocation and then specifying the dates and times, and I'll prepare that and file that so the parties can get a copy of that via the Odyssey system.
Sorry.
Go ahead. I was going to ask if any further points of clarification were needed.
So as far as like the flights and stuff, do Brandon and myself split the costs, or do I flip it the full way back?
It's a good question. Mr. Lovato, do you have any input?
Well, it wouldn't be no problem.
I think splitting the cost seems, at least at this point, equitable. So we'll split the airfare.
Okay, and then the only last question I had, because neither of us came to a conclusion about taxes, and since it's tax season, I had tried to reach out to Brandon since I did have Courtney most of the year last year, and we split the time between the other two girls. I was trying to come up with a conclusion with him, but he just completely leaves me on red for every message that I try to reach out to him about. So
yeah, I think as far as tax exemptions for the 2023 tax year, we're not going to broach that topic today. There's big stuff that's going on right now, and there can be filing of extension of tax deadlines and the like. And I think that's if the parties can make an agreement, that's great. If you can't, then you could file a motion related to the tax exemption. So I think that's something that we need to deal with separately. I think there's a lot going on with the case right now, and to throw that in the mix I'm going to hold off on that. But certainly that can be used at a later time.
Okay, perfect.
So then, as far as just the flight plans, what I'd like to see there is Ms. Hastings make those flight plans. They need to be economically reasonable. And then you'll share that information with Mr. Lovato and share the cost, and then have him pay that half. And then the children will be here no later than the 15th.
Okay, sounds good.
Okay.
Your Honor.
Yes, Ms. Height.
I'm thinking about. I'm thinking about the girls hearing this and hoping that you can give the parties some direction on the best way to inform the girls without vilifying the other party or the court. I wondered if you could help pave the path to letting the girls know that this change is coming.
Yeah, that's big because this is huge news to these young ladies. I think the parties should just keep it as clean as possible, to share with them that the judge heard from mom and dad and the guardian ad litem, and the judge decided that they needed to go and that they'll be going back to Washington, and just leave it at that, and not to say peep or boo about anything about the other parent. It's the court's decision. The court's the one that made that decision. I took into consideration their voices, their input that was provided through the guardian ad litem and the mothers and fathers, but that just basically just stayed laid at the feet of the court. The court made the decision, and not lay any blame or speak ill of either parent, because that's going to be, this has been my experience, that each time a child hears somebody speak poorly of their parent, no matter it's mom or dad, that's a direct assault against them as a person, because half of them came from mom or from dad. So when they hear somebody attacking their mom or their dad, it's an attack on them. And so just to caution the parties to avoid that at all costs, and allow the children to know that the court made the decision, and that's the court's decision only, and not the fault or responsibility of either mom or dad or GAL or them. Hopefully that's
Thank you, Your
helpful.
Honor.
So
Thank you.
I believe that concludes the hearing for today. I'll file that order hopefully by close of business tomorrow, and we'll move from there. Just any final points of clarification, anything that I may have missed?
No, Your Honor.
All right. I appreciate the parties, the way you conducted yourself in a very trying situation, and I wish the best for the parties. That'll conclude today's hearing.
All right, thank you.
You rejoined the call.
Yeah, I am so sorry.
It's okay.
I called DCS and they said no, they don't want. They told me no. I talked to a team lead and my case manager because I don't longer have a case. What do they call it? And they said you have to subpoena the ALJ judge.
Tell me where we left off with your case, because I've been my focus has been elsewhere. So if you could kind of reorient.
Oh yeah, so
what we
abatement
finished off with your case today. What did we finish off with? And
that we're gonna take it to February 14th, and that I needed to get DCS representative, and it's usually Attorney Looney. And so I called DCS to try to get a hold of her. I talked to a team lead because they never, and I even tried to get a hold of my old attorney, James Wong, and they said, no, DCS wants nothing to do with this case. If he wants somebody to come for you, you have to subpoena the ALJ judge, which doesn't make any sense to me.
so I think statute still requires their office to be at least given notice, and then they can make a formal decision, which I think the writing's probably on the wall from what you've said, that they probably won't show up, but at least they've been given notice and an opportunity.
So do I just mail it to the office and that's good enough?
I can't give you necessarily legal advice, but you need to give them notice at an address where, and you could probably talk to Ms. Looney or Ms. Powers on it as far as an address where they could be served.
Okay, perfect. Yeah, because they were just like, no way. I don't know what to do.
Yeah.
All right, I'm so sorry. Thank you so much.
No, I appreciate you zooming back in. Thanks.
Good night.
All right, so that'll conclude the docket for today.